suppose that's the way it is. Maybe. And I'm back. Yeah, she's here. She's not sitting down. Okay, where is she? Is the courtroom deputy there?
Morning, Judge Rogers. This is Tom from the IT department.
Good,
I think
hi.
Ann is in the robing room. I think she's preparing to bring out Chief Judge Srinivasan and Judge Tatel. So
All right.
she should be back shortly.
All right, thank you. So do you have to get back to Ann?
I don't think so.
And please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-5113, Citizens for Responsibility and Ethics in Washington versus United States Department of Justice appellant. Ms. Harrington for the appellant, Ms. Wiseman for the appellee.
Good morning, counsel. It's good to be back with you in person in the courtroom for arguments this morning. Ms. Harrington, please proceed when you're ready.
Thank you, Chief Judge Srinivasan, and may it please the court, I'm Sarah Harrington for the Department of Justice. We ask this court to reverse the district court's order to release Part 2 of the memo to Attorney General Barr because that memo is self-evidently privileged. This case implicates the government's important long-term institutional interests in protecting the integrity of agency decision-making. If agency advisors are chilled from giving principals their most candid advice.
Can I just ask you to boost your decibel level just a little bit, or maybe,
Yes.
Maybe lift the
directly into
microphone or something.
Yeah, of course. Sorry, there's
That's
the
good. Yeah.
shield. I think it makes it harder.
Much better. Thanks.
Okay,
Yeah.
great. Thank you for letting me know. If agency advisors are chilled from giving their most candid advice to principals, that will lead to worse outcomes for agencies and for the public at large. We do not want agency lawyers to write advice memos as if they are press releases, even, and I would say particularly in high profile and politically sensitive matters, which is surely what was happening here.
I don't understand the district court to have disagreed with those general propositions, do you?
The district court thought that the government submissions were misleading and incomplete, that they
I understand, but the propositions that you just presented to the court, I don't see that the district court did not agree with those general propositions. What she was dealing with was the record before her. Is that not correct?
Well, Your Honor, what I'd say is she wasn't dealing with the full record before her, and we think that's where the real error in the district court's decision was, because the district court thought that the government submissions were misleading and incomplete, and the remedy for that is not to grant summary judgment to the plaintiff, but to order in-camera review, and that's what the district court did. And once the district court reviewed the document in camera, then the document itself was part of the summary judgment record, and she wasn't. It was an error for the district court to grant summary judgment without regard to what the memo actually said.
Can I ask you the following question? So suppose that what happened is that there's a conversation between the Attorney General and subordinates, and the Attorney General says, everybody knows there's not going to be a charge brought here. That's just forbidden. So no charge will be brought. But just as a thought experiment, I'm just curious about whether we think that were a charge possible, the evidence would support the bringing of a charge and that the evidence would show the commission of a crime. But it's a pure thought experiment. I'm not going to do anything with it. I just want to sort of reach a decision on my own for my own self about whether that would be the case. Can you let me know your views?
Yeah, so I think in general, just a thought experiment memo wouldn't necessarily be deliberative and pre-decisional. It may be deliberative, but it wouldn't be pre-decisional. But here
it would not be pre-decisional.
Right, or at least would be a much harder case, and we're not asking you to.
Why would it even be deliberative?
I'm sorry, I couldn't hear you, Judge Tatel.
Sorry. Why would it even be deliberative?
Well, I mean, if you had, it would depend on what the content of the memo was. If it reflected some sort of back and forth in reaching a conclusion about that thought exercise, then it might be deliberative. But we're certainly not asking the court to rule on whether a thought exercise memo would be entitled to protection under Exemption 5.
So can I just ask you, when you say that it would at least be a harder case, and I think it may not be the case that it would be pre-decisional, that's because there's no subsequent decision in play, because it's just essentially an academic thought experiment.
Because it's expressly teed up as an academic thought exercise, as I understood your hypothetical.
Yes.
And so that's not to say that an agency couldn't say, well, let's decide this question. We're not sure what we're going to do with it, but it will be helpful to future decision making down the road. We don't know exactly what those decisions would be. I don't want to say that that couldn't be protected under Exemption 5.
Right.
And here,
because there's a potential decision. I mean, you could.
Right.
It could be a circumstance in which the principal would say, I don't think I'm going to do anything with this, but in order to make an informed assessment of whether I'm going to do something with it, let me know your views. I understand that, but I'm just positing a situation in which the way it's teed up is the principal says, we're not going to bring a charge. Everybody knows we're not going to bring a charge, and there's no other particular reason I'd like this information. I'm just curious for my own kind of academic interest, what you think about whether.
I think that would not fall within Exemption 5. Of course, that's not what happened here. Here, the decision that's addressed in the memo is whether the evidence that's set out in Part 2 of the Special Counsel's report was sufficient to show that then President Trump had committed an obstruction of justice offense. And the reason that that decision was made was because the Attorney General was deciding what, if anything, to say publicly about
right. So the second part of that, then, for the construct that we've developed so far, is essential. It would the first part of it alone wouldn't be enough, because the first part of it might go to no end. And I think in the typical situation in which the deliberations are about whether the evidence shows the commission of a crime, it's going to be obvious what the reason is for that assessment, because somebody might bring a charge. I mean, in the typical prosecutorial complex, I don't even know that you would need, for deliberative process purposes, a specification that the ultimate end is the potential bringing of a charge, because it would just be self-evident that that's what prosecutors talk about. This case seems different because here, that obvious option is just off the table by everybody's estimation. So then the question becomes, well, okay, then what's the purpose of what would otherwise be a thought experiment that wouldn't trigger the deliberative process privilege? What would be the purpose of that? And you've identified one, and your briefing identifies that one, which is the potential public disclosure to Congress. And then I guess the question in my mind is, where is that supported in the declarations?
So I guess it was understood to be the backdrop to the FOIA request because it was the statements to Congress in the letter to Congress and in Attorney General Barr's later testimony the following month to Congress that prompted the FOIA request. The Attorney General announced that the decision he had made was about the sufficiency of the evidence in Part 2 of the Special Counsel's report. That's the decision he said he made in the letter. That's the decision he said he had made in his testimony. That's the decision about which plaintiff crew sought information in its FOIA request. That's the decision that's identified in the decision line of the memo that was never redacted and in the parts of the introductory paragraphs that were never redacted. And that's
when you say that's the decision, you're talking
the decision about the sufficiency. But it was all
that could
decision,
be a thought experiment.
What the decision was announced, the decision came to light because it was announced in a public way to Congress, right? So it's true that we could have been clearer about the reason that the decision was being made in our declarations and our summary judgment pleadings. And I want to say forthrightly, we regret that we caused confusion with the way that we wrote those, and we certainly didn't intend that, and we sincerely apologize for that result. But it's clear also now in Part 1 of the memo, which we have released, we did not appeal the ordered release of that part, that that sort of further explains the context for the decision.
Right, but it's hard to see Part 1 of the memo as evidence submitted by the government that would show the purpose, because Part 1 only comes out after the district court issues its ruling, right? And then you chose not to appeal on that. But in terms of whether the district court should have understood that the purpose for which the assessment was being made was with an eye towards public disclosure, it would have to precede the disclosure of Part 1 because that wasn't out there yet.
So two responses. There is one statement in the first Colborne Declaration in paragraph 17 that mentions that the Attorney General had made a public statement after making this decision. Now, that doesn't go all the way to what you're asking. It doesn't specifically say that was the reason, but there was some indication of that.
Where is that?
It's page 17 of the Colborne Declaration.
Paragraph 17?
I'm sorry, paragraph 17 is. Yeah, I don't have the joint appendix of the first. It is on Joint Appendix 51. It says, following receipt of the memorandum, the Attorney General announced his decision publicly in a letter to the House and Senate Judiciary Committees. So that gives context for why the decision was made. It doesn't expressly, it's not an express link, I think, which is what you're asking about. Yeah. But the more important point is that once the district court ordered in camera review, she had Part 1 of the memo. She had the whole memo. And it was error for her to grant summary judgment to the plaintiff based on her view of the pleadings and the declarations without regard to what was actually in the memo itself. So the remedy for incomplete pleadings.
But why? Because if there may be something that she could tease out from the materials that she reviews in camera, but unless the government is telling her that that's the basis for the assertion of the deliberative process privilege, I don't know that a district judge is supposed to make arguments for the government. It would be one thing if the declarations were something, or the briefing, pointed the district court to this as a potential rationale, and then the district court sees the memo in camera and sees that it confirms an argument that the government's making. The question I'm trying to get at is, what would give somebody that impression? Because typically, when the assessment is whether the evidence shows the commission of a crime, it's self-evident that the reason that's being asked is for purposes of determining whether to bring a charge. That's off the table. So then the question becomes, well, okay, then why was that assessment being made? And I didn't see anything in the declarations or in the briefing that would give an indication that this is the reason the assessment was being made.
So, Chief Judge Srinivasan, I don't think that the question, what is the reason this decision is being made, is the essential question. The question is, what is the decision that's being made in the document that we say is privileged? The decision that's addressed in the document, the decision about which advice is given, is the sufficiency determination. It's not about whether to make a public statement. The reason that that decision was being made was because the Attorney General was contemplating whether to make a public statement. But that's not the decision, that's not the actual decision that's being addressed in the memorandum. And so I think there was confusion. The district court thought that we were trying to pretend or give the impression that the decision that's being teed up in the memo is whether to actually prosecute that then sitting President Trump. Of course, that's not, we never said that, and we would have had no reason to suggest that that was the decision because, first of all, nobody would have believed us. It was well known, as you say at the time, that that wasn't permitted. You couldn't.
I would say, by the way, on that score, especially with and I appreciate and understand that the government has expressed regret for misimpressions caused by the documentation that was filed in the district court. If you only look at the reply brief in support of summary judgment. There's a lot of material in the reply brief that would lead, I think, a natural listener, a natural reader, to assume that the decision that was on the table is whether to bring a charge. Because the way that's teed up is the opposing side files a document that tells the district court, well, this can't have been the decision. And the response wasn't the obvious one, which would have been, oh, you're right, of course that's not the decision, something else was going on. It's to resist the argument that was being made and to say, no, that could have been the decision. And it says that a couple of occasions. So I can understand, I think, why the district court would have been operating under that impression.
So I don't disagree with anything you've said. I'll just offer it by way of explanation that our understanding of what the argument that the plaintiff was making was that there was no decision at all left for the Attorney General to make. And that's the decision because the special counsel had made all of the determinations and the Attorney General hadn't sort of gone through the process necessary to challenge those. And so that was what we were resisting. And I will concede that we used language that was not as clear as it could have been. In particular, a repeated use of the adjective prosecutorial, we see now caused great confusion. I want to say that I think a sufficiency determination is a prosecutorial determination because it is part of the process that a prosecutor would go through before deciding whether to bring charges. And on page 3 of our reply brief, we define the prosecutorial determination. This is on page 183 of the joint appendix. We defined we said the Attorney General was making a decision about the prosecutorial decision regarding whether the evidence developed by Special Counsel Mueller's investigation was sufficient to establish that the president had committed an obstruction of justice offense. That is the decision that's addressed in the memo. And so we think that and other things give context to our use of the word prosecutorial to describe what was going on. We also think just the larger context, the backdrop of the request and the things that were happening in the world made clear that the Attorney General could not have been contemplating an actual prosecution, and it wouldn't have made any sense.
I'm sorry, Judge Rogers. I don't mean to.
Go ahead.
It wasn't the prosecutorial. It wasn't the use of the word prosecutorial. Although I take your point, and I appreciate the acknowledgement that the word prosecutorial could be misleading. It was other portions of the reply memorandum where it talked about the decision whether to initiate a prosecution, as if that were the decision on the table. And I can point to those. I think you probably know what those statements are, but yes, they're in there. And that's the response to the argument that was put forward by Crew. And it didn't make the obvious response, which is, oh, that decision was never on the table. And you may be right that based on everything we know about the world, especially in hindsight, what we know about the world now, that decision, in fact, wasn't on the table. But the way that it was written could well lead a reader to assume that decision, in fact, was on the table because that's the way the government was describing it in the reply memorandum. I
understand. And all I can say again, by way of explanation, is that we were responding to what we viewed as Crew's argument that there was no decision for the Attorney General to make. And understand, and I'm not going to fight what you're saying, that the language we used had the result of misleading people and causing confusion. But again, the remedy for government pleadings in a FOIA case that are misleading or that are incomplete is to order in-camera review. And that's exactly what the district court did here. In her minute order ordering in-camera review, she said she wanted to do it to help her make an informed, de novo determination about the privileged nature of the document. And so once she has the document, that is part of the summary judgment record. And if at that point the district court wants to have more sort of adversarial process, once the district court can see the ways in which the government pleadings fell short, then the court can order supplemental pleadings and supplemental briefing. But what is not appropriate for the court to do is to grant summary judgment to the plaintiff based on the perceived failings of the government pleadings, even when the document itself, which is at that point part of the record, is self-evidently privileged.
Well, let me ask you about the government's response to the district court's first order, where this was after in-camera review. And the district court made the statement that under the statutory scheme, the burden is on the government. And having read what the government presented it, the district court concluded that the government had not met its burden, and that the district court was not obligated to try to parse out something, much less to fill in the blanks, that either the government meets its burden or it does not. Then when she issued the opinion on the motion for stay, she repeated that. And what I didn't find is what your argument here has been in part, namely that the district court failed to appreciate that in-camera review was the solution to the government's deficiencies. Where was that argument presented to the district court?
So I don't have, and my red light is on, I assume
Oh, yeah, please.
I don't have our stay motion in front of me, and so I can't point you to the exact pages, but I believe we did say, the document itself is self-evidently privileged. And,
What document?
That the memo, that once she viewed the memo in camera,
The entire memo, reading section 1 as well as section 2, or part 1 as well as part 2.
So our view is that part 1 of the memo was also privileged, but we decided not to appeal with respect to part 1.
Counsel, understand my question. I understand you to say that the reason in-camera review is allowed is so the district court, in part, can understand what's going on, even if the district court has concluded that the declarations submitted by the government are insufficient to meet its burden of proof.
Yes.
Where was that argument presented to the district court? Because the way I read its stay order, it reaffirms that the government never made the argument that some obligation was on the district court having conducted in-camera review. In other words, just as you say it was self-evident, so too it seemed to me that based on the government's concern here, that argument would have been one that would have come to the government's attention in discussing how to respond to the district court's initial order. I don't find that. Rather, as a district court's stay opinion suggests, what the government did was to, I think the district court used the words, double down on its argument.
Right. So, we don't agree with all the district court's characterizations of what we've argued in the case. It was a premise of the district court's request for in-camera review. The district court, in the minute ordering in-camera review, said that the court wanted to make a de novo determination based in part on the memo, that seeing the memo would help the court make a de novo determination. And so, in our view, that
is the government's position, and I understand the argument. What I'm asking is whether that argument was ever presented to the district court in haec verba. In other words, whatever the deficiencies of the agency's declarations, if the district court sua sponte decides to conduct in-camera review over the government's opposition, then that is the review that determines whether or not the government has met its burden of proof, or maybe your argument is only that that can give rise to an obligation sua sponte by the district court to seek further declarations from the government.
So our argument
was that argument presented?
So again, it was said by the district court in her request for in-camera review. And so it's not, you wouldn't normally require a government lawyer to say, you have to look at this piece of evidence and that piece of evidence. It's just part of the summary judgment record, and the district court understood.
Is that response to my question, is that the government never made that argument to the district court?
Judges, I don't know if we said it expressly in our stay motion, to be honest.
That's all I need to know. Thank you.
But I don't know if we said it expressly.
Ms. Harrington, I want to ask you a different kind of question here. So in Sierra Club, the declaration in this, your declarations say that the Attorney General saw this document prior to sending his letter to Congress, right? And you cite that for the proposition that this is pre-decisional. But in Sierra Club, the court said that that's not enough, that the document has to, quote, help the head of the agency, whoever it is, here the Attorney General, help the Attorney General formulate his position. So what, and it's your burden, it's the government's burden to show that this was, and if it isn't that, it's just explanatory, right? You agree with that. If it's just a memo that explains a previously made decision, then it's not pre-decisional, it doesn't qualify. It has to help him formulate his decision. And what can you point to in the record that suggests that that's what this was here?
Judge Tatel, I don't think it's quite right that the document itself has to help the Attorney General formulate his decision. It's the advice that is memorialized in the document that has to help the Attorney General.
What's the difference between those two things?
Well, I point that out just because
the advice, the document contains the advice that's in it.
The document contains advice, but this particular document, it became clear, was finalized and signed 2 hours after the Attorney General sent the letter. And so I don't want to answer your question and give the misleading impression.
No,
that
I have a different question about that. But I want to know what, I mean, assume I think that's what the law is. Can you point to anything in the record, anything at all, that suggests that the Attorney General was formulating his position during this time? That is, that it wasn't a memorandum drafted in support of a decision that had been made Friday night. That's what I'm looking for.
Well, so
is there anything that suggests at all that, as far as the Attorney General was concerned, this question was open at any time during those 3 days?
I mean, I think, yeah, so there are declarations that say it was pre-decisional, that the advice...
Wait, what? But saying they're pre-decisional is the conclusion. It doesn't tell us whether or not, I mean, even if I'm willing to accept, well, I will, I accept the declaration's proposition that he saw these ahead of time. Fine, that's what you say. But I don't think that answers our question about whether it's pre-decisional. He could have seen it ahead of time, and it could have been a document that was simply drafted to explain the decision he had made Friday night. It seems to me you have to show something more. And I'm asking whether there's anything I've missed here.
But there's a couple of things. In the declarations, it describes that there were various earlier drafts of the memorandum.
That they were what?
There were earlier drafts of the memorandum that were given to the Attorney General in the course of the weekend over which, he wrote the letter to Congress and made...
Is there anything about those memos that suggests that they weren't simply earlier drafts of an explanatory memo?
I think if you look at the memo itself, it has all of the sort of indicia of being pre-decisional. It is written in the form of giving advice. It is not a memo that says, here are the reasons you said you're making this decision, we're writing them down, right?
Well, I certainly wouldn't write it that way if I were trying to protect this from disclosure. I mean, why would anybody write a memo that way?
I think, if you're trying to memorialize decision of an...
The question I'm trying to get at is, if you just look at the record we have before us, just the existing record in this case, including your declarations and the document, what this looks like is that so the first draft of the letter to Congress was done Friday night. This memo didn't surface until sometime late the next day. And it wasn't issued until after the Attorney General sent his letter to Congress. And in addition to that, in his letter to Congress, the Attorney General said, this is a decision made along with the Deputy Attorney General, who was intimately involved in drafting this memo. So if you just sit back and look at the record we have, what it looks like is a memo drafted to justify or explain a decision previously made. That's not a pre-decisional. That's not protected. And since it's the government's burden to prove that this is covered by an exemption, I'm looking for any evidence to suggest that my impression from what I've said so far is wrong. What is there anything I've missed in describing my perception of what I see this? What have I missed?
So I think part of your impression comes from the timing of the memo and the letter being written sort of simultaneously.
Part of it, only part of it, but go ahead.
That happens all the time when you have something that's happening quickly. You could have a bench memo and a draft order come together to a judge. And it doesn't mean that the bench memo isn't advice giving and pre-decisional. It might just be that the timing is such that you need to draft
Right,
them
but
at the
if you
same
look at the
time.
bench memos I get or the opinion letters I wrote in the many years I practiced law, you can see in both of them a discussion of what the options are, of what the position should be, a discussion of contrary evidence. And that's what I don't see here. It's so, and again, don't misunderstand what I'm saying. I'm simply stating to you as an observer here what the record looks like to me. And to me, the record, that impression I get suggests that this document does not qualify. And what can you do to dispel that view I have? Can you find, is there anything? Is there anything in the declaration I've missed? I haven't seen it. There's no emails or anything. We don't know about that.
I would say the best evidence is the memo itself, which again is written in the form of giving advice. It's written from subordinates to a superior. The authors of the memo didn't have decision-making authority. These are all things that this court has said are indicia of something being pre-decisional. It gave the Attorney General the opportunity, the option at the end to accept or reject the advice. And the substance of the advice was given to him before he made his decision. That we know from the declarations. I think to the extent you're suggesting that there's a suspicion that the Attorney General said to the drafters of the memo, here's where I want to come out at the beginning of the process, that wouldn't be enough to make it not pre-decisional or deliberative.
Well, but why not? You see, because it's the government's burden to prove this. Not, I mean, you have to make your case that this is in fact pre-decisional.
Yes,
and it can't. We all know how opinion letters are written. I mean, you're totally right about this opinion letter. It says it's addressed to the Attorney General. It's addressing the legal issue. But come on, I mean, law firms write opinions letters like this all the time. That's what they look like. And they're designed to support a decision that was already made. That's what this one looks like. But
I don't think that there's any indicia of that in this case. And there's no indication anywhere in the record, in particular in the memo, that the Attorney General adopted the reasoning of the recommendation memo as his own. I just want to say, I think it's particularly important when you have a decision maker say to his or her advice givers, like, here's sort of where I'm thinking we should go with this. It's particularly important to protect the ability of the advice givers to give candid advice, because you especially want them to be able to say, you said you wanted to do this. This is why we think it's not a good idea. Here are things you should think about for the long-term consequences of that. And so we want to be able to protect ex ante their ability to really give their candid advice, in particular when they're trying to talk someone out of something. And so I don't think the fact that you might think that the Attorney General gave an indication of where he was heading would suggest that it's not pre-decisional.
Let me make sure my colleagues don't have additional questions for you, Ms. Harrington.
Thank you.
Thank you. We'll give you some rebuttal time.
Good morning, and may it please the court. The Department of Justice made a strategic decision in this case to defend withholding portions of the memo at issue as legal advice and prosecutorial analysis provided the Attorney General to make a prosecutorial decision. Prue challenged that characterization, arguing that the Attorney General lacked the authority to prosecute the memo, prosecute the president, and that the memo's true purpose was to falsely shape public perception about the special counsel's, the special counsel's obstruction of justice evidence in advance of the report's publication.
So two things, just to be clear. One, you argue that the Attorney General had delegated the prosecutorial authority here to the Deputy Attorney General earlier on. And I'd like to know whether you stick with that. And secondly, what of counsel's argument that we just heard in response to Judge Tatel's question, particularly the hypothetical that even if the Attorney General had said, here's what I want to say to Congress, now write the memo justifying that. And the memo is then written. but it comes in saying, well, we've looked at this independently and we think that's the way to go. Or here are some other options for you to consider. What's your response to that?
Well, Judge Rogers, as to your first question, if I can.
Yes.
Would you repeat your first question? I was caught up in your second one. I apologize.
My first question, you state that the Attorney General,
the authority,
long before these events that we're discussing this morning, had delegated to the Deputy Attorney General the decision whether to prosecute the president.
Yes. Our argument, Your Honor, was actually that having appointed a special counsel, the matter resided with the special counsel, and under the department's regulations, they carve out a limited role for the Attorney General. And where the Attorney General disagrees with the decision that the special counsel makes, there is a process that the Attorney General must follow. We did also— I
understand it. What your document said was the decision to prosecute had been delegated, that the Deputy Attorney General was to decide about the appointment of a special prosecutor. All right,
yes.
All that is consistent with what you said, but I want to be clear as to what is your position before this court.
Well, we remain of the view that once the special counsel was appointed, the Attorney General did not have the authority to prosecute the president. That was outside of his purview. But we also argued to the district court and would argue here today that separately, under the department's own policy about not prosecuting a sitting president, he couldn't have prosecuted the president either. I hope that answers your question. And now—
Ms. Weissman, well,
yes, I'm sorry.
Judge Rogers, did you have a follow-up? Or?
So were you going to follow up?
Well, I know you had a second part to your—
I'm sorry to my colleague. Was he going to follow up or was he going to ask a question on another subject?
He's prepared to answer the second part of your question. So you just keep going.
And the second part of your question was as to the memo, and if the memo were phrased as the way you described. You know, there are a variety, obviously, of hypotheticals, some which could be covered by the privilege, some which could not. But we submit that the circumstances here, it's clear that this was a process that was memorializing a preordained decision. And that's clear from the context. As the district court noted, when the department got the special counsel's report on March 22nd, the volume devoted to obstruction of justice was nearly 200 pages in length. And of course, beneath that report were hundreds, if not thousands of pages of evidence. The department claimed that it looked at all that stuff. It applied the principles of federal prosecution. And as the district court noted, the department had barely had time to skim the report, much less analyze it. This is just further evidence that also was reinforced by the emails that were disclosed to Crew, on which the district court relied. The district court, as you know, prepared a whole chronology of how this played out. The memo came to the department sometime on March 22nd. By the evening, they had already put pen to paper to draft the letter to Congress that would set forth the Attorney General's position that the evidence was not sufficient to prosecute the president for obstruction of justice. You know, by the
suppose you're right about that. Why couldn't it be that, okay, so Friday night, let's just assume, yeah, maybe they had a pretty good view about what their position was Friday night. They could read the executive summary. It's not so hard to even read the couple of hundred pages. Maybe they didn't have time to get into the underlying documents by that point. But so during the week, and they evolved this opinion letter, which may well have dug much deeper and reaffirmed their original instincts. Why wouldn't that be perfectly fit perfectly under the exemption.
Well, you're right that there could have been more play in the decision-making process than I have suggested.
Wait, say that again? What?
There could have been more play in the decision-making process than I have suggested. But that said, what that would mean is that earlier version would be protected by the deliberative process privilege. But the timeline here shows that by the time the Attorney General got the memo, had already received all the advice. He had considered that advice. He had acted on that advice.
Well, how do you know all that? That's not in the record.
Yes, it is, because he wrote a letter to Congress memorializing that. The group were working on those two documents in tandem. There's nothing to suggest any variance between the letter to Congress.
But I don't understand. I'm sorry, go ahead.
Just one thought. Do you think there are any circumstances under which the development of a memo simultaneously with the making of the decision could be pre-decisional, could be deliberative?
I think there are circumstances, yes.
Give me an example.
This is not one of them.
Well, just give me an example of one that would be.
Well, it would have to be a case
It would have to
where the decisional process was still an ongoing process at the time the memo was created, because it all goes back to the purpose of the deliberative process.
So is that the defect here? Is the defect from your perspective that the government hasn't shown that?
Yes, that is.
But what about Ms. Harrington's answer to my question? She should just read the opinion letter.
I'm sorry.
Her answer to my question about that was the best evidence that this is deliberative is the opinion letter, is the memo itself.
We don't the memo.
Why is that wrong?
It's not wrong, but here we have the added.
It has to be wrong for you to win your case.
Well, no, here we have the added benefit of the timeline. We have evidence that was introduced in this record that came from the government in response to Cruz's FOIA requests, emails that lay out and give much more detail to the process that produced this memo than anything the government presented to the district court.
So I didn't understand the district court to accept the proposition that this was a fait accompli and that all the decision had already been made and this was just papering over a decision that had already been made. And the reason I didn't understand the district court to support that proposition is that the district court acknowledged that this actually might have been protected by the deliberative process privilege if the right arguments had been made by the government. Right? That's what the district court said on page 338.
Yes, that is
the application. And it couldn't have said that if it thought that this was just a fait accompli, right? So it was possibly protected by the deliberative, if I can just finish, it was possibly protected by the deliberative process privilege. And even the district court understood that to be the case and accepted that proposition, right?
You're correct. She did not go, the district court judge does not go as far to say this is a fait accompli. She did, however.
But that is the argument that you're making, I think.
Well, all we're suggesting is the evidence strongly suggests that this was not a true deliberative process, that it was prejudged from the outcome.
I don't think she accepted that proposition either, because she thought it actually could have been a true deliberative process if the government had made the right arguments about what the deliberative process was going towards.
Yes. But her decision also notes how little time there was for the department to have truly engaged in a deliberative process. And that's when she's discussing the separate ground for her opinion, which is that the memo is not pre-decisional under, given the timeline and the authority and the purpose of the deliberative process, which is to protect a process, not simply deliberations that are completed.
But I think we have to be very careful about adopting any kind of doctrine that would prevent the following kind of dynamic from playing out in the government. The principle says to subordinates, I have a pretty good idea of where I'm going. I think I know where I'm going. Obviously, persuade me otherwise if you think otherwise, but let's start to write up the analysis. Give me a recommendation. Obviously, if you're thinking through it and you think differently, try to persuade me, but I've got a pretty good idea of where I'm headed. That still, I think, would fall within whatever recommendation ensued as a result of that would still fall within the deliberative process program.
I certainly agree that had the government presented those facts, this would be a much stronger case for them. That, of course, is not the argument they made. That's not what the district court found. And the district court also noted that this was a process that all the parties were working in tandem, including the Attorney General.
But that part, I don't understand. That part of it doesn't seem to do a ton of work, because it would be natural for all the parties to be working in tandem if it was all part of the same decisional calculus, which I think everybody, including the government, agrees it was. It's just that the decision hadn't been finalized until the ultimate decision was made to send the letter to Congress.
Again, I think it would raise the question of whether this was a true deliberative process. But as the district court pointed out in its state decision, the primary reason for her ruling was the arguments that the government had advanced as to why this memo was privileged were demonstratively false.
Right. So can I focus? I'm glad you went to that. Can I focus on that for a second?
Yes.
So if we're not talking about pre-decisional in terms of temporal sequence, if we're talking about whether the government pointed to the right decision, then I take your argument, and I understand the district court's argument that the decision that was being pointed to was perceived to be an ultimate decision about whether to bring a charge.
Yes.
And the response to that is, well, that decision was never on the table. So that, to the extent that that's the argument the government was making, it's just contradicted by the government's own acknowledgement at this point. So that one can't be it. So then the question becomes, well, what about this other purpose for having this assessment of whether the conduct constituted a crime? And the other purpose would be for purposes of determining whether to disclose to Congress. Now, as to that, the district court said that that could have been actually an appropriate occasion for assertion of the deliberative process privilege. The district court just didn't understand that to be an argument that the government was making. And my question about that is, the memo to Congress says that it was informed by OLC's determination. So it's a matter of the public record, at least, that the memo that now is the subject of your FOIA request was in part going towards that purpose. And if that's the case, then does it matter that the declarations and the government submissions might not point to that?
Yes, it matters, because this is a FOIA case. And FOIA cases are unique in civil jurisprudence because the FOIA is a mandatory disclosure statute subject to narrow exceptions. And because of that, the government, even though it's the defendant, bears the burden of proof. And if it fails to meet that burden of proof, the presumption of disclosure prevails. So it was incumbent on the government, not the district court, as they argue, to provide its full arguments, to supplement them as necessary. The jurisprudence from this court teaches that. For example, in Vaughn v. Rosen, the government tried to make a new argument on appeal to support its Exemption 5 claim. And this court said, you had ample opportunity in the district court. There was briefing on cross motions for summary judgment. The precise situation here, you failed to raise it, and you have waived the right to raise it now on appeal. The government here also had ample opportunities. There were multiple briefs filed on cross motions for summary judgment. The government submitted 3 separate declarations. And at no time, either before or after the court ruled, did the government ask for an opportunity to supplement the record or better explain its arguments. It ignored completely Rules 59 and 60, which were the obvious procedural vehicles for a party that believes that the district court just misunderstood their argument or overlooked something. So this is a case that in the end, it was not decided as a sanction, as the government suggests. The order of disclosure flowed naturally from the fact that the government had failed to carry its burden of proof. And as important, the government talks about the importance of the deliberative process privilege, which of course the district court acknowledged and noted that her decision rested on the facts here and was in no way with any disregard to the importance of the privilege. But equally, if not more important, are the fundamental principles of FOIA. So
let me ask this as a follow-up. If the declarations had said at some point the following, and I'm looking at JA 297, which is the unredacted portions of the memo, and section 1 is entitled, "The Department should reach a conclusion on whether prosecution is warranted based on the findings in Volume 2 of the Special Counsel's report." if the declarations had said the memo was designed to assist with the determination of whether the department should reach a conclusion on whether prosecution is warranted, and the reason the memo was designed to do that is because it could result in public disclosure to Congress. Would that, at that point, even the district, I think the district court would have thought that the deliberative process privilege would apply, and I take it you wouldn't disagree with that proposition.
I would not disagree, although what the court actually said in her opinion at JA 250, which is footnote 11, the district court said the court recognizes that internal deliberations about public relations efforts could be covered by the deliberative process privilege. And I think it's very telling here that in its reply brief on appeal at page 11, the Justice Department expressly disavows that this was a public relations effort. So on the one hand, they're arguing that the district court failed to consider other reasons that might have supported its argument for privilege. And yet at the same time, they're disavowing that this was.
This is at the bottom of page 11.
Yes, correct.
Although Attorney General Barr's decisional process culminated in the issuance of a public statement, the privilege advice at issue in this appeal, which the district court reviewed in camera, is not about public relations. That's
exactly. And I don't think you can reconcile that then with a claim that the court, whether it's framed as what to tell Congress or what to tell the public, it was as the district court viewed it, that was a matter of public relations. And that was the argument the district court identified that the government could have raised, but did not.
So let's just disregard for argument's purposes the sentence at page 11 of the reply brief. And let's assume that a sentence along the lines of what I was hypothesizing was in the declarations. Then at that point, you don't take issue with the proposition that the deliberative process privilege would have been appropriately found to be.
If the government had raised that argument, yes. But as the district court noted, it's not up to the court to tease out arguments for the government. The burden rests on the government to fully present its arguments, and it did not do that here. I do want to stress something that I think the government glosses over entirely, which is that the construction that Crew and the district court made of the government's arguments to be arguing that the Attorney General was making a decision about whether to prosecute the president did not result from some careless slip of the tongue, so to speak. By my count, in the government's briefs and in their declarations filed below, the word prosecutor, some variation of it, was mentioned 74 times. In addition, the Justice Department repeatedly invoked the authority of the principles of federal prosecution as providing the analytical framework for its prosecutorial decision-making. And the purpose section of that manual states expressly it's intended to guide the exercise of prosecutorial discretion with respect to commencing or declining prosecutions. And as this court noted in its questions of the government, when we challenge the authority of the Attorney General to prosecute the president, not only did the government double down, as the district court said, but it never even hinted that we had misunderstood its arguments. And in its summary judgment brief, it devoted nearly a full page to case sites standing for the proposition that when the department is deliberating over whether to prosecute, those deliberations are protected by the deliberative process privilege. So this was not an errant slip of the tongue. This was a repeated argument that the government made in the district court that misled both Crew and the court. And the in-camera review, the government's position here, I'm not sure I quite understand it. We agree that having looked at the document in camera, that resolved the issue because what the court was facing was competing arguments, conflicting arguments about the nature and purpose of the memo. And it resolved that factual conflict by reviewing the memo. And what the court found from its in-camera review was that the memo did not say what the government said it said. It did not, its purpose was not as identified by the government.
Suppose that the memo, what's now unredacted, was what was disclosed at the outset.
I think that would have made it a much harder case for us and an easier case for the government, because I think it's clear from the district court's opinion that what troubled the court is that the government deliberately redacted any reference in the memo to its policy about prosecuting a president. And it's really inexplicable, because here they have argued that that was such a central fact that was widely and publicly known that it was just sort of baked in. If that's the case, why did they redact all references to that policy? Why did two declarants from the Justice Department assert under penalty of perjury that that was privileged deliberative material that couldn't be disclosed? And why did the Attorney General tell Congress in his March 24th letter that he made his decision that the evidence was not sufficient to prosecute the president without any regard for constitutional barriers, that it was a standalone decision? So I just don't think any of that can be reconciled with the government's position on appeal.
Ms. Weissman, let me ask you how this case would come out in your mind if there were one slight different fact. Suppose the draft letter to Congress had not been prepared Friday, but wasn't prepared until Sunday after this opinion, after this memorandum was prepared and went through all the drafting process. Would it come out differently?
So your question is, if the memo was not prepared until Sunday?
No, if the letter to Congress hadn't been prepared until Sunday. In other words,
I see.
We know that they prepared a draft of the letter to Congress Friday night, right?
Right.
Suppose they hadn't done that. Suppose they had worked all weekend on the memo, and then Sunday afternoon, after the Attorney General saw the memo, they wrote the letter to Congress.
I'm not sure it would necessarily change the equation, but it would be very different. I mean, that's obviously not what happened here.
Yeah, I know. That's why I said.
Right. I mean, I think, again, the question becomes, what role did the memo play in the decisional process? And as long as there when the memo was created, if it was created while there was an ongoing decisional process, then I think there's a strong argument that it's protected.
Well, what would the government have had to show in this case to make that argument? What would have satisfied you? Let's go back to the real facts now. The letter to Congress was drafted on Friday. The memo comes up on Saturday. Just stick with the facts we've got. What would the government have had to show here? As you point out, it has the burden of proof.
Well,
what would it have had to show to convince you that this was, in fact, deliberate?
It would have had to show that at the time the memo was finalized, there was still an ongoing deliberation, which is not the fact here. Now, the government has responded that the Attorney General could have changed his mind, but that's very unrealistic. The Attorney General had publicly committed to Congress, and the letter had become public, that he and the Deputy Attorney General, essentially acting on behalf of the department, had made this determination. I think there's no realistic expectation that he was going to change his mind. So again, I think what you have to look at is what role does a document play in a decision-making process? Because the whole point of the deliberative process privilege is to protect the integrity of the decision.
Suppose there was evidence. Suppose there was evidence that when the Attorney General got the draft of this memorandum for the first time, he convened a meeting of all his people, and they had a huge debate about whether this memo was, in fact, accurate. That is, whether the conclusion that there was insufficient evidence to charge the president, that was a debatable question at that point. Would that have been enough?
I'm sorry, I couldn't hear all of it. If the conclusion was that there was insufficient.
No, if there was evidence that there had actually been a healthy debate, around the Attorney General about whether there was or was not sufficient
Yeah.
evidence.
Well, that would be evidence that suggests that the document did in fact play a role in an active, ongoing deliberative process.
Right. So that
yeah,
would be enough. That's one thing that
would appear to be enough, yes. Because again,
And so if the declaration had added a sentence which said the Attorney General, I don't have the language in front of it. It says the declaration says that the Attorney General reviewed a draft of this memorandum before Sunday. And then it had added another sentence which said, and convened a meeting at which there was a healthy debate about whether or not there was sufficient evidence to indict the president. Then that would be enough for you, right?
I'm still
That's all it needs?
No, because it wouldn't, you still have to look to the final memo itself. That would support the notion that earlier drafts of the memo were pre-decisional and should be protected by the deliberative process privilege. But if it's the case that based on everything the Attorney General received, and that appears to be the case here, he made a decision, he considered that advice, he made a decision, he conveyed that decision to Congress, and then he memorialized that decision was memorialized in a memo, then you still have, earlier drafts might be protected, but it doesn't change the fact that at the end of the day, if the memo is just memorializing a position that the agency settled on, which is the language from Fish and Wildlife in the Supreme Court, then it is not pre-decisional.
Now, I want to follow up on a question Judge Tatel asked, but only if Judge Tatel's not going to follow up.
No, I'm not. You should.
Okay. Then, as I understood the question that he asked you, he said, what if the letter to Congress had post-dated the approval of the memorandum so that it would have happened on Sunday and you thought that would have been a different case? You acknowledge that that would be a different case, I think. And my question is that not this case? Because on page 208 in the second Colburn Declaration, the top of the page, it says, I have recently been informed that prior to making his decision and sending the letter, the Attorney General had received the substance of the advice contained in document number 15. So the advice, part of the declaration, did predate the sending of the letter. The fact that the advice might not have been memorialized until afterwards doesn't necessarily change anything. What matters is that the advice actually was given beforehand.
No, I respectfully disagree. Again, I think the fact that there might be earlier written versions containing this advice means that up until the point a decision was made, they would qualify as pre-decisional and may be protected by the privilege. But once the Attorney General made a decision, once he acted on that advice, then a memo that memorializes his decision, which is what we think happened.
I think when you say the memo memorializes the decision, depends on what you mean. If it memorializes the deliberations, and if it memorializes the recommendation, the fact that the memo isn't finalized until afterwards can't matter. I mean, what if the final memo just corrects a typo? And one of the drafts that you say would have been protected by the deliberative process privilege and that came beforehand contained the typo. I don't think anybody would say that because a new memo was issued that corrected the typo after the decision was announced, that then is not protected by the deliberative process privilege.
Of course, we have no indication that that happened here. But again, I think you have to look at the role that a document plays in the decision-making process. And if the Attorney General, as all the evidence suggests, had settled on a position and that his decision was based on advice he had received, and then he basically adopts that as his final decision, a memo containing that adoption is not pre-decisional and not entitled to protection. And I just want to point out here, I mean, this is a situation where the special counsel did an investigation and made public in volume 2, a nearly 200-page summary of the evidence that he had found and his analysis of that evidence. The Department of Justice disagreed in some material ways with the special counsel's finding and memorialized its own view and its own analysis in a memo. And the idea that that should be protected as deliberative, I think is contrary to Exemption 5 and its underlying purposes, And it's contrary to the whole point of the privilege, again,
Okay.
which is to protect this process.
Let me just make sure my colleagues don't have additional questions for you, Ms.
No.
Ms.
Yes,
Wiseman.
I have one question. I was intrigued by some of the arguments presented by amicus. And I wondered to what extent your argument embraces the notion that, very much as the Chief Justice's first question, the counsel for the government inquired, would this process be available under Exemption 5, where the only matter under consideration is a hypothetical, that there is no decision as such on the table applying the principles of prosecutorial decision-making, because that's already been decided. So that by defining decisions so broadly as to encompass this type of hypothetical investigation, I don't know, bleeds into your argument about what is the whole purpose of the requirement that exemptions under FOIA be narrowly construed.
Yes, I agree completely, Your Honor, because when you strip away, as you must, the argument that the government made in the district court that this was intended to help the Attorney General make a decision on prosecuting the president, you are left with this abstract, hypothetical, decision-making on hypothetical questions with no real practical purpose, completely, untethered from any agency action or even any potential agency action. And yes, the deliberative process privilege does not stretch that far. And again, as you point out in your question, it goes back to the purposes of the privilege.
Well, let me just follow up, if I may, Judge Tatel. So I understand a lot of the discussion here this morning, including the court's questions, which I understand does not necessarily reflect its views. The suggestion is that even if here, the government's declarations and other evidence presented to the district court did not make clear the nature of the decision actually being made, nevertheless, there was a decision to be made on the table, not whether to actually file charges against the president for obstruction of justice, but rather, given, as the Attorney General said, the special prosecutor did not evaluate the sufficiency of the evidence that its investigation had uncovered regarding obstruction of justice, and therefore it remained for the Attorney General to address that.
And that is, as I understand, the heart of the government's argument. The problem with that is it completely misses the question of why did that process have to be taken? There was no decision at the end of it. Again, it's reduced to a hypothetical, because why was it necessary for the Attorney General to make a decision about the sufficiency of the evidence if it was a given at the outset that the president could not be prosecuted because of constitutional considerations?
So the court's questions have suggested, well, the declaration could have been more revealing, but I just want to be clear on your position. And maybe it's that we don't have to decide this question in this case, but you're going so far, or Crew is going so far as to say a decision as to what the Attorney General should say to Congress regarding the Inspector General's report is not the nature of a decision falling within the exemption under FOIA.
No, that is not our position, and I'm sorry if I have suggested
No,
that.
I'm just trying to be clear.
Right.
My question.
That is not our position. Our position is that, as the district court recognized, that could have been a potential argument the government could have raised,
Right.
and it made the decision not to, and instead raised another argument that proved to be demonstrably false. So yes, had the government presented a full range of arguments, we might be in a different situation. But here, as I started out saying, we believe the government made a deliberate choice to defend this the way it defended it, and the facts didn't bear it out. It didn't meet its burden of proof, and therefore disclosure was the appropriate remedy. Thank you.
Thank you, Ms. Weissman. Ms. Harrington, we'll give you 3 minutes for rebuttal.
Thank you, Chief Judge Srinivasan. I'd like to start, if I could, by sort of focusing the court on what I think is the central question in this case, which is what should happen in a FOIA case when a district court finds that the government's submissions are inadequate. And I think it's important to keep in mind how FOIA cases work. They're unlike other cases in that the government actually has the information, but believes that it is entitled to keep it secret. And so the government has to submit declarations and summary judgment arguments that kind of talk around what the document is about. That's just baked into how FOIA works, because it wouldn't make any sense to require the government to come in and say what's in the privileged material, because we're trying to keep it secret, right? And so it happens not infrequently that the government's declarations and summary judgment briefs don't quite get the job done, that this court or the DDC finds that there isn't sufficient information to make a judgment about whether a document is entitled to be withheld under Exemption 5 or some other exemption. And so the remedy for that is either in-camera review or asking the government to submit supplemental declarations or supplemental briefs. There are lots of examples of this court basically remanding a case to a district court after finding that the government submissions gave no indication of what the decisional process was, or suggested that it was something maybe that it wasn't, or gave very...
Let me be clear about your argument. You are stating, as I understand it, that the district court has a sua sponte obligation if it is tending toward a decision that the agency's declarations are insufficient, to request those declarations be supplemented by the agency. No request has to be made, but it's not necessarily. Let me finish my sentence so you understand what I'm concerned about. Because the way I heard your argument, and maybe I misunderstood it, was that even after the district court has conducted in-camera review and is satisfied that the government has in its declarations to the district court misrepresented what is the actual decision on the table, then the district court still has an obligation, sua sponte, to request supplemental declarations, and that process must be exhausted under FOIA before the district court can order the documents at issue be released to the public.
That's not our argument, Judge Rogers, and thank you for the opportunity to clarify. Our view is that once the district court has conducted in-camera review, the district court can rule on whether the document is entitled to be withheld under one of the FOIA exemptions based on the document itself. The district court also has the option of ordering supplemental declarations and pleadings, and this court has indicated there's some virtue in that in some cases because it allows the adversary process to play out, gives the plaintiff a chance to sort of argue against the government's clarified arguments about why a document should be withheld. But once the district court, this is sort of our fundamental submission here, once the district court reviews the document in camera, the document is part of the summary judgment record. And if the document is self-evidently privileged, as we believe that part 2 of this memo is, then the district court, it's not available to the court to grant summary judgment to the plaintiff just because the district court thought that the submissions were inadequate.
But it has to be self-evidently privileged in a way that's commensurate with arguments that the government's making, either in its declarations or in its papers. And just to put ourselves in the shoes of the district court, what the district court saw was a memorandum from the government that said the following, and I'm looking at JA 193 to 194, and this is the reply memorandum. On 193, The government says, moreover, as a memorandum containing analysis about whether evidence supporting or it supports initiating or declining a prosecution, document number 15 fits neatly within a broader category of documents that are generally protected by the deliberative process privilege. And then the next sentence, plaintiff's arguments in response rest only on its misinterpretation of the DOJ special counsel regulations and its own irrelevant speculation, unsupported by admissible evidence, that the Attorney General was not engaged in a legitimate decision on whether to initiate or decline prosecution of the President for obstruction of justice. Down at the bottom of the page, for all of these reasons, plaintiff's supposition that document number 15 was not part of a deliberation about whether or not to prosecute the President cannot overcome the deference to the agency's affidavits. So that's the picture that's been painted for the district court. So the district court is looking later in camera at the memorandum with the mindset that this is the position the government's putting forward. And so the fact that the memorandum, when reviewed in camera, might support a different rationale that the government hasn't put forward, I don't think there's any law that suggests that the district court then has to look at the memorandum, treat it as itself evidence that supports a rationale that the government hasn't put forward to that point. Now, you may think either the government did put forward that rationale or that it was so self-evident that the government must have been putting forward that rationale that the district court should have seized on that part of the memo. But that's the context in which the district court conducted its in-camera review.
Well, Chief Judge Srinivasan, you have read the most damaging parts of our own pleadings to us, but those aren't the only things we said, right? You have to view them, or we wish the district court had viewed them in context of all the other places where we said specifically that the decision that's teed up in this memo is about the sufficiency of the evidence in Part 2 of the special counsel's report and whether that would show an obstruction of justice offense. Again, we thought it was perfectly clear, sort of in the world and against the backdrop of this litigation, that there was...
But I don't think anybody disagrees that that's what the memo was designed to do and was always advertised as being designed to do. But I think we've already established that if that was only an academic exercise, that wouldn't be enough. So it had to be going towards something. And the one obvious thing that usually that assessment goes towards is off the table. But the government's submissions led to the natural impression that that was actually on the table, or else a court or anybody else reading it might think, well, then why else would someone have been engaging in that assessment? And if you look at the memo, you see why. But the government hadn't said that.
I disagree with your assessment that it suggests that there was an actual prosecution decision being considered, because I just think it was perfectly clear that that was not available. And we would never have tried to convince anyone, let alone an Article III judge, that Attorney General Bill Barr was actually contemplating bringing criminal charges against then President Donald Trump. No one would have believed it because it was well known that we couldn't do that. But also, it wouldn't help us establish that this is a privileged document, because the privileged nature of the document does not depend on whether there was an actual prosecution being contemplated.
But then the question becomes, if that's off the table, and I will say again, and I know you're not really fighting this, that the government submissions made it look like it might not be off the table. But even if you put that to one side, then the natural question that arises is, okay, then why is that assessment being undertaken? And as to that, now we know, because Section 1 of the memo tells us. But at the time that the district court rendered its decision, that wasn't out there as something that the government was supporting.
But it was known at that point that the Attorney General had made public statements about this sufficiency determination. And so I think it was natural to understand that that's part of the reason that the decision was made. And that's what prompted, in fact, the FOIA request. Again, we think we have decided not to appeal withholding of Part 1. Part 1 actually doesn't talk about making public statements. It says, it gives advice about why this decision should be made and said, if Part 2 of the Mueller report were to become public, we might want to sort of remove the cloud that could be hanging, the cloud of accusation that could be hanging over then President Trump. And so that is public now. And just to respond to there was some discussion about what we said on page 11 of our reply brief. That's specifically referring to the part of the memo that's at issue in this appeal, which is Part 2 of the memo, which is not about public relations. It's only about the sufficiency analysis.
Ms. Harrington, feel free to tell me if you think I'm oversimplifying things here.
Could you speak a little bit louder, Judge Tatel? I'm sorry.
Feel free to tell me if I am oversimplifying things here. We are looking at this case from a different perspective than the district court. It didn't evolve in stages here. We've read the memo, right? We've read the memo. You've told me that the best evidence that this memo is deliberative is the memo itself. So, and this is hypothetical, if I look at the memo the timing of the memo in relation to the letter to Congress and who was involved in it, and agree and think the district court was right that it's not pre-decisional. Is that the end of the matter, or are you saying we have to give the government another chance to convince us, in the words of Sierra Club, that the memo helped the Attorney General formulate his position?
Judge Tatel, I don't think there's a definite answer to that. We would appreciate another chance, but I think if you look at the evidence that's in the record and determine that it's not pre-decisional, and I'll just clarify, the district court didn't actually hold that it wasn't pre-decisional. She expressed doubts about that, but didn't make a holding on that. If you come to the conclusion that it's not pre-decisional based on what's in the record, I think you could rule on that. What this court more often does is remands to the district court to give the government another opportunity. And I think the reason—
What would we remand for in this case?
For the government to maybe submit a supplemental declaration giving—
what?
For the government to submit a supplemental declaration giving greater context for how the decision was made.
Why would we do that since, maybe we're going over. Why would we do that since the government already made its case that this was?
That's why I started where I did in the rebuttal, because I just want to point to the court to how FOIA cases ordinarily work. And the fact that the government doesn't get it right in its first try of talking around a privileged document.
I heard that point, yeah.
Doesn't mean that it shouldn't.
You're right, we do that quite frequently. But since you've told me that the best evidence that this is deliberative is the document itself, what is there?
I mean, I think the document does show that it's pre-decisional because it's written as advice from a subordinate to superiors. It gives the decision maker the opportunity to accept or reject the advice. The Colborne declarations describe that the substance of the memo was delivered to the Attorney General before he made his decision. This court in Meade Data Central, which is an old FOIA case, said it would exalt form over substance to say that advice given to a decision maker is pre-decisional if it's written down beforehand, but not if it's recorded afterwards. And we think that absolutely applies here.
Unless there are any further questions, thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 20-1313 et al. City and County of San Francisco petitioner versus Federal Energy Regulatory Commission. Ms. Mapes for the petitioner, Mr. Ediger for the respondent, Ms. Ward for the intervener.
We'll just wait to begin until the court clears and counsel for the next case come in.
Morning.
Good morning, counsel. Ms. Mapes, please proceed when you're ready.
Good morning, Your Honors, and may it please the court. We're here to talk about a practice that PG&E has imposed under its wholesale distribution tariff, under which it denies secondary service for all but the smallest of loads. That secondary service allows loads to connect at a lower voltage level without expensive primary facilities that could cost hundreds of thousands of dollars more. If it's too expensive or if it's physically impossible for San Francisco to install those primary facilities, San Francisco loses the customer. It becomes a PG&E retail customer. PG&E then serves those facilities using the same secondary facilities it would not allow San Francisco to use to serve the customer. FERC should have rejected this practice as the anti-competitive pretext that it is. Instead, it rubber-stamped it. In doing so, it did not make a single finding that the medium-sized or small loads discussed here, interconnected as secondary, threaten the reliability of the grid. It did not address a single operational argument made by PG&E or San Francisco's rebuttals to that argument. It did not even explain why PG&E can serve its own loads of that size as secondary, why it can serve previously connected San Francisco loads as secondary, why it can serve loads belonging to other wholesale distribution customers as secondary.
So let me ask you, the agency did submit an affidavit or declaration that talked about safety and reliability. And I understand your point that at least I haven't found in the record a place where the agency said, for example, San Francisco requests X, but if you look at X, which PG&E denied for secondary service, there are safety problems in that 1, 2, 3, 4, and there are reliability problems 1, 2, 3, 4. So that's not there. But what is the burden here? Because FERC's orders describe the system. It describes the relationship that's been going on for many years. And now it also says that it's not as though there's an actual policy, because sometimes San Francisco's requests have been approved. So what measure of specificity is required here?
Your Honor, I have a couple of answers to that. The first is that under the Federal Power Act, FERC's decisions need to be supported by substantial evidence. Second,
that's more than a scintilla. All right, so that's why I want to know.
That's correct. However, Your Honor,
though the agency didn't describe a system, it described in terms of arguments just this morning, it's self-evident. This is a complex system, involves many interconnections. PG&E has to make these determinations, and it has made these determinations and said why, but it hasn't said in this particular example, we didn't think the safety was adequate.
Your Honor, I think there's a number of things in the record that make FERC's rather conclusory determination that PG&E should have total discretion not supported by substantial evidence. The first is that, as you noted, FERC found that PG&E does not have a policy of denying these loads. It grants them in some situations. That is actually flatly contradicted by the record. The record shows, and PG&E readily conceded in its brief, that in July of 2019, PG&E informed San Francisco that, well, in the past, it had granted a few accommodations for loads above 75 kilowatts. It was no longer going to do that going forward. That is in Joint Appendix 284, and you can see PG&E.
That's not what the commission was reviewing in the decisions that we're considering, right? That's a prospective determination that still, as I understand it, that still hasn't been finally resolved because it's pending. It's pending now.
I would disagree with that, Your Honor. It is true that after the commission issued its decision in this case, PG&E then filed a new tariff stating that it would not grant secondary service at all. However, the July 2019 letter was before the commission in this case. It was under the previous version of the wholesale distribution tariff that was before the commission, and the commission did not address that in its order. There's actually another part of that that the commission failed to address, which is that if you look at the charts that FERC, the PG&E included below FERC, and that FERC included in its brief here, FERC uses those charts as evidence to show that PG&E was granting secondary service on a regular basis. San Francisco alleged in its complaint that PG&E began this practice in late 2017, I believe November of 2017. Most of the instances where loads over 75 kilowatts were connected, shown in those charts, are in 2015 or 2016. There's a few in 2017, and there's only 3 in 2018. Because FERC didn't set this case for hearing, the record is not as developed as it might otherwise have been. But I think of the very few secondary in 2018, many of them might have been in process before 2017. So San Francisco filed this complaint relatively soon after PG&E began this new practice. FERC did not set it for hearing, and PG&E became more definitive about its practice as the briefing was ongoing at FERC. It was clear that as of July 2019, PG&E would not accept any more requests for secondary service above 75 kilowatts. The other thing I would say about that is that the tariff actually has a definitive process to ensure that the safety and reliability of the system are maintained. If you look at the tariff itself, it has a process by which San Francisco or any wholesale distribution customer submits an application. PG&E then has an obligation to do what is called a system impact study at the customer's expense to determine whether that interconnection can be undertaken safely. If it cannot, PG&E has the obligation to use due diligence to expand or modify its distribution system to provide the requested service. The distribution system in the tariff is explicitly defined to include the secondary system. PG&E has not been doing that, and it has stated so in the record. When it receives a request for secondary service above 75 kilowatts, its practice as of 2017 has been to deny it and to tell San Francisco to submit a new application for primary service. It does not perform the required system impact study. So there were a few cases in which San Francisco was able to go through a lengthy negotiations process with PG&E to resolve the issue, but it was not receiving proper service under the tariff.
Ms. Mate, the tariff, am I right that the tariff itself is silent on where PG&E has to provide primary and secondary service, right?
It is, Your Honor, as to which voltage levels.
Yeah, so in that case, don't we have to defer to the Commission's interpretation?
Your Honor, I would say that the Commission is entitled to deference as to its interpretation of the tariff.
Yeah.
I would also say that because the Commission disregarded the process the tariff lays out, the system impact study process, the obligation to expand and modify its distribution system, it does not pass the arbitrary and capricious test, and even with deference, its interpretation fails. San Francisco is not, as FERC seems to be stating that it gets total discretion over which voltage levels can be interconnected. It wants the tariff process to be followed.
And what do you do with the Commission's statement that in utility interconnections, when you talk about utility to utility interconnections, that primary service is the norm in the industry?
Your Honor, I would state that that's misleading, and
You would say what?
That's misleading. And in fact, I think we use sloppy language in one of our briefs as well, and I apologize for that. Utility to utility interconnections are normally at higher voltage. In many cases, most cases, I believe, that would be at transmission level voltages, where you would have, say, PG&E interconnecting with its southern neighbor, Southern California Edison.
That's even higher than primary.
That's even higher. So the kind of situation where we have here, where San Francisco's loads are dispersed within PG&E's service territory, is relatively unusual. It is not unheard of. There are other wholesale distribution customers, particularly the Western Area Power Administration, that has a very similar setup and which does receive secondary service.
I didn't read you to be taking issue with the premise that, putting aside the situations in which it's even higher than primary, that primary would be the normal mode for utility to utility. I didn't read your briefs to be taking issue with that.
I don't think we would. I think we fully admitted this is a relatively unusual situation. And, I would also say that even if we took primary service at all these circumstances, it would still be an unusual situation. The interconnection is just not the normal one.
Counsel, you're welcome to continue or to reserve your time for rebuttal, whichever you prefer.
Well, I would make one more point, which is that I think it is worth talking about the Western Area Power Administration for a minute. That is another wholesale distribution customer that is similarly situated to PG or to San Francisco.
Could you just say, who are you talking about?
It is the western area.
Oh, okay. Now I know. I just didn't hear you. Yeah.
That's what the
Western area. Okay, fine.
The one that have a settlement agreement.
Yeah.
So they have a settlement agreement with PG&E. I think they do take service under the same wholesale distribution tariff. That settlement agreement is pursuant to the same wholesale distribution tariff and enables them to take service under it. Like San Francisco, Western has many small points of interconnection scattered throughout the area in which they operate. In San Francisco's case, that's more constrained within the city. In Western's case, it's more spread out in Northern California. PG&E allows the Western Area Power Administration to add these new secondary points of delivery. It has not pointed to any physical or operational or technical differences between them. As far as we are aware, as in the record, none exist. The fact that Western receives this service pursuant to a settlement does not allow, under this court's precedent, FERC to claim that entirely insulates it from undue discrimination. This is open access service. Every customer under this tariff should receive comparable service if they're similarly situated, and that is not something that has happened to date. And if there are no further questions, I can reserve the remainder of my time for rebuttal, Your Honor.
Thank you, Ms. Mapes. We'll hear from the commission now. Mr. Ediger.
Good morning. Thank you, Your Honor. May it please the court. I'm Scott Ediger for the Federal Energy Regulatory Commission, and thank you for hearing the case today. There are just a few points I would like to make in response to the arguments by San Francisco. And I do want to begin by emphasizing the point that the commission has made throughout the orders, challenged orders, is that the normal norm for interconnection from utility to utility is to connect at primary. And it truly is something exceptional that San Francisco is asking for here. And again, as we were just discussing, the only other arrangement of an eligible customer under this tariff is with the Western Power Administration. And I want to go straight to that. The commission addressed the settlement that
that may be the norm, but this all goes back to this Kachechi arrangement where Congress, the whole thing was designed, as I understand it, to let San Francisco compete, right, with providers with utilities like PG&E. It's a different, because of this history, it's not your normal utility connection. Isn't that right?
This is indeed.
And also, and if you look at what PG&E has done in both of these cases, but with its narrow interpretation of the grandfathering clause and with its limiting of secondary service, it's basically eviscerated or greatly limited the ability of San Francisco to compete, which was the purpose of this whole Kachechi project 100 years ago, wasn't it?
I don't think so, Your Honor. I think San Francisco still can compete, and it just has to follow. I think what the commission is saying here is San Francisco has to follow the industry norm.
Well, in other words, it can't compete the way it used to, right?
I would agree with that, Your Honor. Okay,
and isn't that a pretty strong argument for suggesting that the normal utility to utility practices just don't apply in this case? We have a different situation here.
I would respond to that. It is an unusual situation, but I would respond to that by taking the next point from the industry norm is the next point is that there's actual practical explanation for why this is the industry norm. And while this is an unusual situation, those practical matters still apply here. And the commission addressed this in the initial order, what we call the 2020 order at paragraph 38. This is at JA 363, where the commission made the finding that primary facilities are necessary for the safe and reliable operation of the system. And I would also reference the court to paragraph 22 of that same order. This is at JA 357, the commission there described a little more about PG&E's rationale and explanation.
Let me just interrupt you. I have a couple of questions. I'm sorry to interrupt you, but you've raised a couple of issues. You just said that, I think you just said that, PG&E is responsible for the safety and reliability of the system, right? And so, but I didn't see any place in the record where FERC addressed whether or not the voltage level related to safety. Where did it do that? Where did FERC say that the above 75 creates a safety or reliability problem, but below 75 doesn't?
The link is to the facilities that...
To the what?
The link is to the facilities. And what the commission is saying is that primary facilities achieve the safety and reliability benefits.
Yeah, but that's the conclusion.
That is a conclusion.
This is an APA case, right?
Yes.
So FERC's decision FERC has to respond to the arguments that are made by San Francisco here. And one of their arguments is that FERC hasn't demonstrated that there's a relationship between safety and these particular levels. They say also that under 13.4, PG&E has to exercise due diligence to expand its distribution system to provide secondary services whenever they ask for it. Now, they may be right or wrong about that, but they say there's nowhere in the record where FERC responded to that. So their point is they've made arguments about PG&E's responsibility to respond to their request for secondary service. They've made arguments that there's no rational connection between the particular levels that PG&E has picked here. And their argument is that FERC didn't respond to any of it, which is kind of classic APA, isn't it?
The commission did respond to the service argument, and that leads the commission's analysis.
Wait, what do you mean by this? You mean the first or the second points I made?
I'm sorry, Your Honor, I can't.
The first or the second point? Which did FERC respond to?
The commission made the finding that PG&E has not denied service to San Francisco. And in support of that, I would point the court to Section 215 of the Tariff. And this is in the joint appendix in the other case, the 2000.
What about the letter that Ms. May mentioned?
Which letter?
The letter where PG&E, she said, yes, they were providing service on a case-to-case basis, but there's a letter dated...
By 2019?
Yeah, the July letter, which says we're not going to do it anymore. And FERC didn't respond to that either.
The commission did make the finding in a couple places in that the rehearing order, paragraph 10, note 27, this is a JA 15, that some of the examples that we cite in our brief had occurred after 2017. And I'll also point out that PG&E filed this information in, I believe the information went up through 2018, and PG&E filed it in May. So it provided the most up-to-date information, and that's the information that we relied on in our brief. And I think it demonstrates a couple of things, that of the interconnections that have been made since San Francisco started taking service under the 2015, over 40% have been for greater than 75 kilowatts, and a majority of those have been at secondary service. So it just doesn't, it's not the case that PG&E has been denying service to San Francisco under the tariff.
Can I ask a question about although I don't want to cut off Judge Tatel if...
Go for it.
I have a question about the filed rate doctrine and its applicability here. So as I understand the commission's understanding of the filed rate doctrine. If there were an unwritten policy to the effect that for loads larger than 75 kilowatts, the service is going to be primary service. That's not anywhere spelled out in the tariff, obviously. But if that were the policy that PG&E were implementing, then it would be inconsistent with the filed rate doctrine not to have that policy in the terms of the tariff.
I think that's right, Your Honor, and I think that's what the commission was getting at.
Right, so then the question becomes, yeah, I think that is what the commission was getting at paragraph 12 on JA 416 to 417 as I read that. And so then the question becomes, if that would need to be in the tariff, then if there's a policy that's just the default assumption, as opposed to an inexorable rule, it's a default assumption that if it's above 75 kilowatts, the service is going to be primary, but we can have a negotiation to figure out whether we're actually going to allow secondary service. And why doesn't that also need to be in the tariff? What's the difference between an ironclad rule and a default assumption for purposes of the filed rate doctrine?
For the filed rate doctrine, I would refer the court to the rule of reason here. This is what Your Honor is suggesting would be a very difficult rule to codify in the tariff. And what the commission has found here is that PG&E has actually been flexible in its application.
But I don't know what's difficult about the default assumption. I mean, it may be that what's difficult is what happens to try to controvert the assumption. But in terms of the existence of the assumption to begin with, it seems like a pretty straightforward specified rule, which is that the default assumption, unless, let me put it this way, if there's no further submissions by the city, then service is going to be primary if the load is over 75 kilowatts. Not inexorable, because there could be some other stuff. And I might agree with you that as to the other stuff, that's not reducible to the level of specificity that would implicate the filed rate doctrine. But in terms of the existence of the assumption in the first place, because it's tethered to a particular level, 75 kilowatts, and it just implements an assumption, I don't know enough about and I'm not suggesting that I know the answer. I don't know enough about the filed rate doctrine to understand why there would be a distinction between a rule, an inexorable rule that would have to be in the tariff, and a default assumption that's equally specific as to 75 kilowatts, but for some reason that doesn't have to be in the tariff.
At the end of the day, I think in both cases, whether the assumption is in the tariff or whether it's not, at the end of the day, this is something that PG&E was flexibly working with San Francisco, and I guess my answer would be that it wouldn't matter because what really matters is the particular facts of the case. And these are the things that we couldn't codify easily in the tariff. And I think under the rule of reason, the commission was right not to demand that codification. And the commission referred to some of these things in paragraph 43 of the 2020 order. This at JA 366. It talked about load size, location, and other factors. There's also references in the record when a request is made too far from the facilities, that secondary voltage isn't sufficient to serve that.
But here you have San Francisco. It's not all spread out. And then the other comment was, well, some of the parts are not numbered, so it's difficult for inspectors to inspect and report. I mean, that's just, so put some numbers on. It seems to be the obvious response there. And then if there is some part of northern San Francisco that's too far, FERC can say that, but it hasn't said that, has it, as to particular requests? And now we have this letter, and I know your point about you're just going to 2017. These options aren't available. So do you understand that to mean that even if you're in settlement negotiations, FERC would not be able to agree?
I'm sorry, I'm not sure I follow the question.
We're all having problems getting our questions across, all right? Your position, as I understand it, is PG&E is willing to negotiate on a case-by-case basis. And it put that chart out, and the agency put it in its opinion. But then San Francisco comes back and it talks about what's really happening on the ground. And I don't see where the response to that exists in the order. I mean, it talks about factors, et cetera. It talks about an industry preference. But San Francisco, and I don't see PG&E in saying it's not, we're different for all these reasons about all these multiple interconnections. And a lot of them are high voltage areas. In other words, if you read the record, it looks like there is this settled position.
Well, I'd respectfully disagree with that, Your Honor. And I think our charts support what the findings of the commission were. And the commission made the specific finding that the interconnections had continued, and but
you would agree, wouldn't you, that all of San Francisco's requests are not in remote areas, and that all of San Francisco's requests, if they involve units of the system that are not marked, they can be marked?
Yes, Your Honor. In addition to the point about the markings of the facilities, the PG&E also, and the commission talks about this in paragraph 22. This is at JA 357. And there the commission cites PG&E's answer at page 17, and also the previous paragraph 21, and further references to the answer and the declaration of PG&E's expert.
But we've been through that, haven't we? These are general statements. They're not specific to particular requests by San Francisco. And furthermore, do you agree that PG&E is not following the tariff provision?
No, I don't agree with that. I believe what the tariff says is that PG&E must provide service, and service is defined in section 215 of the tariff. And this is in the JA on the other case, JA 370.
Well, take Judge Tatel's questions as framing the question, okay? And you can put San Francisco out of business, basically. I understand that because it doesn't say PGA has to provide the service that's requested. But doesn't it have to say why you can't have it, particularly since there are these provisions of the tariff that talk about expanding facilities and also having a study done at San Francisco's cost?
That's right, Your Honor. I would. There is a provision in the tariff for expanding the system, and that's at 13.4 of the tariff. There are two problems with that. First of all, that section refers to denial of service under the tariff, and then I would refer the court back to the definition of what is service under the tariff, and that's section 215.
So
and
your
there is
position is it's anything PG&E says it is, right? So what do you do with the other provision then that says that there's supposed to be this study at San Francisco's expense?
I would point out that furthermore in that section, there's a reference to good utility practice. And that gets us back to where we started with this, is that the arrangement between to provide utility to utility service at secondary voltage is entirely novel and entirely
It's not, counsel, on this record, because we know that settlements are entered. We also know that some of PG&E's customers, own customers, are receiving secondary service. So that's just not a viable argument, is it?
So a couple things in response to that. First of all, with respect to the one other eligible customer that's receiving secondary voltage, that is by settlement, and the commission discussed that in its order.
I know it says it's under section 210 and 211. We're under 206. Yes. Therefore, what? The tariff still applies in all those cases.
Well, what the commission was saying in paragraph 42 of the initial order was that the arrangement with Western is a bargain for arrangement that resulted from a settlement. And
my point, counsel, is that I'm not contesting that is what happened. But the fact that PG&E agreed suggests that maybe the fact these utilities aren't marked, maybe the fact that there don't seem to be any safety problems, it would be an unusual situation, would it not, for PG&E to agree to such a settlement if it forced it to violate good utility practice and everything else?
I think that's right, Your Honor, but I think that's only part of the equation. The import of the bargain for agreement is that there was a trade-off, and PG&E, I would submit, made a determination in the settlement that allowed for it to accommodate this unusual circumstance for Western.
And so you acknowledge at the beginning that San Francisco presents an unusual circumstance. It's not the typical.
Yes.
All right. So I don't know where these arguments get us. Doesn't the agency have to be more specific?
The agency was specific here, I would submit, Your Honor. I see I'm out of time. I can...
you can answer that question, and I know that Judge Tatel has another question as well.
I would just refer the court again to the norm that the commission found here, and the unusual circumstance of connecting at secondary for the utility to utility connection. And I would refer the court as well to paragraph 38 of the initial order, which fleshed this out in addition to its summary of PG&E's arguments at paragraphs 21 and 22.
Mr. Edinger, I've spent quite a bit of time trying to figure out the relationship between this case and the next case. And since you're arguing that, I think that's a fair question for me to ask you this question, which is that, and I want to emphasize, this is a totally hypothetical question. But if I think FERC is wrong in the grandfather case, if I think it's wrong, and that decision has to be vacated, will all grandfathered facilities continue to get secondary service? In other words, is this case just about non-grandfathered customers? Do I have that right or not?
This case is, in the case of grandfathering, the San Francisco, so the other case, San Francisco does not own facilities for those delivery.
No, but if FERC is wrong about that, and what governs is 212F. In other words, I don't want to get into that argument because we'll do that in the next 10 minutes or 5 minutes. I just want to know that if you lose that case, is this case only about non-grandfathered, or am I missing something?
I think going forward, Your Honor, that there would, if I understand San Francisco's argument in the other case, is they're advocating for a much broader class of grandfathering going forward. So they would argue, and if the commission were to lose that case, there would be a broader class of facilities that...
So the answer to my question is yes, right? Grandfathered facilities will get, however broadly you define it, narrow or broad. If you define it broadly, as San Francisco does, grandfathered facilities will get secondary service, right? So this case, either way is only about ungrandfathered, right?
That's correct.
Okay, thank you.
If my colleagues don't have additional questions for you, Mr. Editor, we'll hear from PG&E Counsel. Ms. Ward.
May it please the court, my name is Alexandra Ward on behalf of the intervener for the respondent, PG&E. First, I'd like to address questions about the system impact study. The system impact study process was not raised by San Francisco, so their failure to raise this argument means it cannot be presented to this court. But for further background on how a system impact study works, it comes after the initial review. PG&E reviews the application. There's nothing in this record that speaks to whether or not PG&E disregarded its system impact study practices. Next, I'd like to address the operating numbers question by Judge Rogers.
Can I just be clear then? Before PG&E knows what the system impact study would show, it rules on the request?
Your Honor,
and it
PG&E
rules on the request on the broad statement of concerns about safety and reliability?
When PG&E receives an application, we conduct an initial review and determine whether or not there's capacity.
The answer to my question, yes.
Can you please repeat your question, Your Honor?
My question is, as I understand what you're telling me, PG&E interprets the tariff to mean that it can consider a request, deny it on concerns generally about safety and integrity and reliability, without knowing what the system impact study would show as to any of those factors.
The answer is no, Your Honor. PG&E would not just deny a request. What PG&E looks for in an application is whether all of the information is complete on how the connection and how you would connect at that point of interconnection. And then
so my hypothetical is it's a complete application down to the very last attachment. Every statement is complete and accurate. But the utility says we have no obligation to ask the requesting party to conduct this study because our concern about safety and reliability convinces us we should not grant it.
No, Your Honor, what PG&E would do is decide, okay, this request means that you need a primary interconnection and let's study the primary interconnection. So it's a matter of studying the details of the best point of interconnection.
So do you understand what I'm getting at? San Francisco has said, A, it has limited space. B, if it's not given the secondary, it's got to spend all this money on these facilities, money it doesn't have. And no one wants to know what the system impact might be. And given that PG&E is the provider, and so it has this overview, et cetera, of the system as a whole, it doesn't need to know the details. In other words, this tariff provision, which appears to be there for a purpose of informing the utility, and maybe the utility will simply say, well, we don't need it, I mean, the provider. But that's not what you're saying they say. They just don't need to ask for it at all.
San Francisco.
And they would only ask for it if they say, well, we're not sure, so we want to get this study.
If San Francisco would like to interconnect a point, has an application submitted to PG&E, PG&E will review the application and, per the terms of the tariff, conduct a system impact study if necessary.
PG&E does it at its own cost?
PG&E does it at San Francisco's cost, Your Honor.
Now, as I understand San Francisco, it's not asking for these studies.
Your Honor, I think this case really does not come down to the particulars of system impact studies, and there's really not enough in the record to discuss how PG&E conducts its system impact studies. What's really at issue is the fact that San Francisco wants to continue to receive the type of service that it previously received under its old expired agreement, when it didn't have to own any of its own facilities, and it depended on.
As I understand it, the utility's point is we're concerned about safety and reliability of the system as a whole. Furthermore, some of these areas may be remote. Furthermore, the individual units are not marked. What more has the utility provided?
Your Honor, I believe that the record has evidence about the engineering rationale behind why primary interconnections.
Well, I've read the declaration. It's very general. He doesn't believe it's good practice.
Yes, and beyond that, the operating numbers, which you've asked about earlier, there are no operating numbers at the secondary voltage level. And so
why can't you put them on? That's what I don't understand.
According to my
PG&E didn't say it's impossible for us to add these numbers.
It's standard utility practice, Your Honor, in which only primary facilities receive operating numbers, and the switch logs are focused on primary interconnections, and so it gives the directions.
Standard operating procedure. We're under a tariff. This is a situation of a request by a requesting party that is not the usual type of request. I'm just trying to understand what we're dealing with here. Otherwise, it looks like there is this unwritten policy.
Your Honor, the use of the operating numbers go in the practice of having a switch log. That all goes to why it's important for PG&E as the service provider to have discretion when looking at each application on a case-by-case basis on whether.
I don't think that's an issue, all right? Candidly, FERC has agreed to that. And that's not what the court's questions have been addressing. I think I understand your position.
Can I'm sorry, were you done, Judge Rogers?
Yes, I am. Thank you, Judge Tatel.
Can I just pursue this operating number thing? Maybe you could just explain that to me. As I understand it, secondary connections don't have operating numbers, right?
That is correct, Your Honor.
Okay. And so what's a switch log?
So a switch log that's the directions that the utility has on how to operate the system. So an example would be if San Francisco has a police station that's interconnected, and PG&E needs to go out there and for purposes of maintenance, or if there's an emergency, we can read the switch log and all of the operating numbers, and we have a clear guide, and there's a distinction that the ownership stops at the meter panel. But it's after that point in which, and that's why there's the importance of having clarity in the system and a distinct division, is because if the end user, the police station, is taking service from San Francisco, the secondary system does not allow for a clear understanding of whose materials are whose.
Okay, so I see. So I hope I understand this enough to ask this question, but why doesn't that same problem, that is the absence of operating numbers, apply to all of the other customers PG&E serves at the secondary level, like, for example, the 96% of San Francisco customers, PG&E's own retail customers, and the Western Area Power Administration? How come it doesn't? They all get secondary service. Why hasn't the absence of operating numbers been a problem for them?
Well, the difference, Your Honor, for PG&E's retail customers is that. we understand where the ownership stops, and then it's our retail customer.
Okay, what about the 96%?
For the previously interconnected, the 96% of interconnections that are at secondary, Your Honor, those were connected at a time in which, under the 1987 interconnection agreement, where we treated San Francisco like a retail customer, which it is not. And so now, good utility practice and looking forward, which is why we're ending, and this is in our brief, that we are currently stating that we will no longer offer primary service, and when the settlement agreements end with Western, we will no longer offer primary or secondary to them.
I think that's just circular. You said it's not been a problem in the past for primary service, but now we're not going to offer it anymore. Why can't PG&E just assign operating numbers to secondary service?
Sorry, can you speak up, Your Honor, just a little bit?
Yeah, I'm sorry. Why can't PG&E just assign operating numbers to customers getting secondary service?
Your Honor, from my understanding is that secondary equipment does not include operating numbers, and the operating numbers are only applied at primary.
That's not in the record, by the way, is it?
That is correct. That's just from my understanding, speaking with our engineers.
Yeah, when I read this, I wondered, my first reaction to this, when I saw your argument about it, I looked in the record to see what the explanation was for why you couldn't just assign operating numbers, and FERC didn't even ask that question, did it? FERC didn't address this at all, right?
Your Honor, I would say that FERC, as the agency that understands the system, has technical expertise, understands that interconnections at primary are the preference for utility to utility interconnections, and that although might not, you can't add it to secondary might not be in the record, is something that FERC that FERC could have understood with their expertise when making that determination.
Well, too bad they didn't let the court know. I guess my point is, I can understand if I own a piece of equipment, I don't want PG&E coming in and putting numbers all over it. All right, but PG&E can say, well, we're not going to provide service unless we can put numbers so that we can identify the equipment. And therefore, when we get a call from the police station saying there's a fire or something's not working, we'll know what piece of equipment to look at because our service logs will identify it. I mean, that's a problem that PG&E has that appears to be of its own making. That's all I'm getting at. And maybe there's a good explanation, but it's not in the record.
Your Honor, I would say it's really about the utility to utility relationship that's most important. It's the police station in your example shouldn't be calling PG&E. They should be calling San Francisco as their provider.
So the call comes in from San Francisco saying we've got a problem at the police station. PG&E says, well, we have no idea where it's located because those facilities are not marked. I mean, counsel, this is not rocket science. That's all I'm getting at. Anything further?
I have
one more question.
Yeah.
Just Tatel.
We had a debate, a little bit of a debate with Counsel for San Francisco and FERC about this July 2019 letter from PG&E and its role in this. Do you want to say something about that? Can you help us understand what role that letter played and whether FERC is right that FERC says in its decision that PG&E had no written or unwritten policy of denying service for interconnections serving more than 75 kilowatts. But this letter seems to suggest the opposite, doesn't it?
Your Honor, when I read the letter, I don't think that it explicitly states that moving forward from that date on that we are no longer providing service, secondary service for loads above 75 kW. What Mr. Hallam-Michael's declaration says and what's PG&E's practice is that when CCSF applies for an interconnection and requests secondary service, that PG&E looks at the existing distribution infrastructure in the vicinity of the service request to determine whether there'll be sufficient existing capacity to serve CCSF's load at secondary. So it is PG&E's practice, and there have been connections beyond the letter in 2018. I think that's most important to note if you were to look at filings at FERC, that there have been connections at secondary loads above 75 kW.
Okay, thank you, Ms. Ward. Well, Ms. Mapes, you have, I believe you had 7 minutes left in your argument. Use for rebuttal if you'd like.
Thank you. I have a few points I'd like to clarify if I can. The first is I want to address what Ms. Ward just referenced, which was Mr. Hyla-Michael's declaration, and you can find this, I believe, at JA 172. And unfortunately, FERC and PG&E have been quoting one sentence of that declaration, where he does say that if they receive a request for secondary service, they evaluate the capacity on the system. If you continue on to the next sentence, he says that if that request is for 75 kilowatts or above, they will deny it. I would also say that we did address the process for connecting loads under the tariff in our initial brief. Unfortunately, I don't have the JA site, but that was pages 53 and 54 of our brief. So that is not a new argument. And there was one other point I wanted to make a correction on, Judge Tatel, in response to your question about the relationship between this case and the grandfathering case. I would differ with FERC counsel. The primary and secondary facilities at issue here are different than the intervening facilities. So if you look at section 14.2 of the tariff, you'll see a chart showing the intervening facilities needed for primary interconnections and the intervening facilities needed for secondary interconnections. So San Francisco does actually at many points own intervening facilities at primary and at secondary. Those are different sets of facilities. Even if we win in the 212H case, if we lose in this case, PG&E would continue to say that we cannot connect even grandfathered loads above 75 kilowatts to the secondary system.
That's very helpful. Thank you. Okay,
yeah.
Great.
More broadly, I wanted to talk a little bit.
I just ask you to repeat the JA site.
Yes, Your Honor. That Hyla-Michael declaration was JA.
No, the intervening facilities showing the difference.
That was the tariff section 14.2. And I apologize, I don't have that JA site.
I thought you had a listing. No, I've got 14.2. I thought there was an actual listing. All right, thank you, counsel.
There's, I believe it might be there's a chart. It's further down in 14.2. There's a chart showing the intervening facilities for different kinds of interconnections, because it also includes.
Thank you. Right, thank you.
More broadly, I wanted to talk about the relationship of this case to FERC's open access policies, because we've been hearing a lot about, well, PG&E might deny San Francisco's requested interconnection and then negotiate with San Francisco, or PG&E negotiated with Western, or, well, they got that under the old bilateral tariff. PG&E transitioned to service under this open access tariff to San Francisco in 2015. FERC has been very clear that part of the reason it enacted its open access reforms in Order 888 was to remedy the kind of discrimination it found in bilateral agreements under the old system. And frankly, it called PG&E out explicitly in Order 88 as an example of a utility that was creating that kind of discrimination in bilateral agreements, requiring San Francisco to go through a lengthy negotiation for each routine city pool or library that it wants to connect to PG&E's secondary system is more or less the epitome of undue discrimination. It is not open access to PG&E's distribution system, which is what is provided for in its wholesale distribution tariff. And moreover, the July 2019 letter actually says that PG&E won't do that anymore. I believe what it says.
That in the Can you just point me to where that is? July 2019 letter.
Where that is,
Yeah.
I left that over here. The July 2019 letter is at JA 284.
Okay.
And it's discussed in, I believe, PG&E's pleadings at JA 158 and JA 172. And what that says is that PG&E will not continue granting accommodations unless essentially the entire case is settled or the resolution of the entire case is reached. And if a resolution of the entire case was reached, we wouldn't be here. That went up to FERC. FERC denied our complaint. That was the resolution. And unless there are any more questions, I'm going to yield my time. Thank you very much.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 20-1084 et al. The City and County of San Francisco petitioner versus Federal Energy Regulatory Commission. Ms. Mapes for the petitioner, Mr. Ediger for the respondent, Mr. Liebenberg for the interview.
Mapes, welcome back.
Thank you. Good morning, and your honors, and may it please the court. This case, again, concerns FERC's open access tariff for providing service over its wholesale jurisdiction system, open access electric distribution system. The tariff at issue here, the part of the tariff at issue here is not ambiguous. It states that a tariff customer is eligible for service without intervening facilities when it meets the criteria for grandfathering in Section 212H of the Federal Power Act. FERC's central error here is simple. It refused to apply Section 212H of the Federal Power Act in its entirety to this tariff that explicitly references it, that explicitly incorporates it, and explicitly defers to it. Before FERC, the parties, including PG&E, filed a joint brief agreeing to the meaning of the tariff's references. They stated that the parties could not agree on the scope of grandfathering under 212H, that they knew they needed a commission decision as to that matter, and that a delivery or interconnection point would be ineligible for service under the tariff only if Section 212H will prohibit the commission from ordering wholesale service to that delivery point. And under FERC's Suffolk line of cases, which is the primary case law interpreting Section 212H, FERC would not be prohibited from ordering service to San Francisco. But FERC dodged construction of that statute. Instead of deferring, or instead of looking at the plain text of the statute, looking at the text of Section 212H, looking at how it interpreted 212H in the past, and interrogating and reckoning with that precedent, FERC instead stated that it was a reference intended to give certainty to the date as to which grandfathering would attach. Maybe there was some stricture as to class of customers, but it was not meant to refer to Section 212H in its entirety.
Can I just ask a question about the joint filing?
Mm-hmm.
So I thought it was interesting that in this is JA 613, the last sentence of the only full paragraph on that page says the intent of referencing Section 212H in the WTT as it pertains to grandfathering was to ensure that the Commission's interpretation of the statute was incorporated into the WTT's eligibility rules.
Yes, Your Honor.
Which indicates that everybody understood that there was going to be an open question about how exactly the scope of 212H
Yes, Your Honor.
was going to be resolved in circumstances of this case. But what was intended by everybody was that whatever the Commission's interpretation of the statute was, that interpretation would be read into the tariff.
Yes, Your Honor, that was our intention. And while PG&E now states it was intended to be ambiguous, they joined that brief. I would further state that FERC has argued that San Francisco's interpretation of the tariff would frustrate the point of delivery framework of the tariff. That's not correct. The two are consistent. It is true that the tariff has a point of delivery framework and that San Francisco and other tariff customers must apply for service at each point of delivery from which it seeks service for PG&E. But we must demonstrate using the criteria of Section 212H that we are entitled to grandfathering or we own intervening facilities at each point of delivery for which we apply. So the point of delivery approach and San Francisco's approach to grandfathering are consistent. I would say once again that the Western Area Power Administration has a settlement agreement with PG&E, which states that it may add new grandfathered points of delivery, and it does so regularly. Like San Francisco, that is as we discussed, a customer with many small points of interconnection that was receiving service in 1992. And once again, this creates a discrepancy between two similarly situated customers that constitutes undue discrimination. I also think it's worth noting that FERC explicitly stated that San Francisco's interpretation was consistent with the interpretation in the Suffolk cases, which are the major cases in which it has interpreted the grandfathering provision of Section 212H. And if there are no questions,
let me just ask you a global question here. How would you best describe the impact of these two FERC decisions, the grandfathering case and the secondary service case, on San Francisco's system? What's the global impact of this on San Francisco's operation?
Your Honor, I would say that it has created a constant struggle to connect the types of customers that San Francisco has served for decades. We transitioned to open access service, San Francisco did in 2015, under the understanding that loads served under the old IA would be served under the new tariff. That was explicit. And it has become clear throughout these cases that even when we install intervening facilities, San Francisco is then told that it needs to install primary facilities. So it creates layered barriers to service that make it very difficult. And
can you, if you lose both of these, can you quantify for us in some way what its impact will be on San Francisco?
I'm sorry, Your Honor, the question was if we lose both?
Yeah, if you lose both, it's a hypothetical question. But if FERC's two opinions stand, what can you quantify for us what the long-term impact is on San Francisco?
Your Honor, I don't believe I have a monetary quantification. I don't believe I have a numerical quantification. I would say there are some immediate impacts. PG&E has spot network in the city, a certain type of network in the city, just can't take primary connection. So there are certain loads that will never be able to get connected. PG&E has trigger points that terminate service to some of San Francisco's old points in its tariff that it didn't deem eligible for grandfathering. So some of those, if they exceed capacity, might need expensive renovations or to be terminated. And we are also dealing with this additional tariff that's being contested at FERC, which PG&E mentioned in its brief, that would eliminate secondary service entirely, including terminating service to San Francisco's street lights and other small unmetered loads on, I believe, February 27th. So there's a variety.
You heard my question about an hour ago to Mr. Ettinger about the impact of all of this on the Hetch-Hetchy arrangement and enabling San Francisco to compete. Did I overstate that?
The impact on Hetch-Hetchy's service of power? I don't think so, Your Honor. I think that San Francisco has a congressional mandate to bring Hetch-Hetchy power into the city and use it first for municipal purposes. And that's what it's been trying to carry out, and it's been very difficult to do.
Does this, I don't want to put words in your mouth, but do these two decisions, are they inconsistent with that goal? Do they undermine that objective?
These decisions undermine that objective, yes, Your Honor. And I would say that Congress was quite explicit in the legislative history and in the statute that it wanted San Francisco to be an alternative to private power purveyors like PG&E. It's prohibited from reselling Hetch-Hetchy power for resale to a private entity. And so its mandate is to do what it's been doing and attempt to serve customers in the city itself.
Thank you, Ms. Mapes. Unless my colleagues have additional questions for you this time, we'll give you remaining time for rebuttal.
Thank you, Your Honor.
Mr. Edgar.
Thank you, Your Honor, and may it please the court. There are three paragraphs of the Commission's orders that I'd like to emphasize quickly in my time. The first paragraph is the finding in the initial order, the 2019 order, paragraph 68. The Commission found in...
Where is that in the JA?
That is at JA 648. The Commission makes the finding that the tariff at issue here has a delivery point framework throughout, and there are other sections of the order that emphasize that as well. But the Commission made reference to the general rule of section 14.2 of the tariff, and this is at JA 393, and this is also the chart I think the court was questioning about the intervening facilities are also listed on that same page. But at the top of that page, JA 393, the commission made the finding that there is a general rule that under this tariff, the interconnection should be that there should be intervening distribution facilities between.
Mr. Ender, can I just take you back to an antecedent point? You mentioned the tariff. You mentioned 14.2 of the tariff, okay? So let's just look at the language of it. It says that distribution customers must own intervening facilities. Now I'm quoting, except in the case where an eligible customer meets the criteria for grandfathering in section 212H2. Well, that 212H2. So can you just explain to me how the phrase meets the criteria for grandfathering in section 212H2 doesn't incorporate the criteria in section 212H2? I've seen a lot of ambiguous language in the decades I've been at this court. This is not ambiguous. What's I don't understand how FERC got past this problem.
I think the commission explains more at paragraph 69 of the 2019 order at JA 649 is that this language should not negate what it found in other sections of the tariff.
And I should add, excuse me, that's what the parties agree it means, right? That's what San Francisco and PG&E both said it means. It was intended to incorporate the 212F standard into the tariff. So you've got the plain language of the tariff, and you've got the written agreement of the parties that that's what it means. I'm having trouble getting past that.
A couple points to that. First of all, footnote 154 of the initial order, the commission recognized that the parties believe that precedent under the commission's precedent under section 212 should apply here, and the commission flatly rejected that interpretation.
But what about the language of the tariff? Well, first of all, we're interpreting a contract, basically, right? We're applying contract principles to interpret this, and you've got language. Plain language, at least I think it's plain, and you've got the interpretation of the parties to it. What's FERC's basis for saying that's not what the parties say that's what they intended? FERC says that's not what they intended. How can FERC do that? How can FERC say that isn't what the parties intended when the parties told FERC that is what they intended?
The commission has an obligation, again, as the commission explained in the footnote, that the commission acknowledged what the parties had agreed to here. That wasn't, the commission didn't overlook that. And the commission, of course, is in the best position to interpret its own precedent. And what the commission has decided was that precedent doesn't apply here. And while that isn't what the parties agreed, the commission explained in that footnote that the precedent applies to other sections of the Federal Power Act and not here.
I don't understand that conceptually, because suppose you have two parties that come together in a contract and they say, we're defining a particular phrase, and the way we're going to define this phrase is by reference to the following decision of somebody, decision A. It doesn't matter what anybody else thinks about that. The parties have already told you that decision A is going to define it. But the fact that the author of decision A might say, well, I never contemplated that it would govern that. It doesn't matter, because the parties have said, we're going to operate in accordance with whatever decision A says. And that's exactly what the parties said here at JA 612 and 613, is that those kinds of the Suffolk decisions, the interpretation of 212H, all of that is going to feed into the interpretation of the tariff. So I don't understand what room there is for the commission to have a different understanding than what the parties themselves have already told us is their own understanding.
Clearly from that joint brief, and I believe it's page 3 of the joint brief, while the parties did to a certain extent agree that the precedent should apply, and again, the commission acknowledged that, clearly there was a great disagreement about what grandfathering meant in
Under 212H,
the tariff. And that's not in the statute.
I don't think there was any disagreement about the tariff. I think there was a disagreement about how the statute would be construed.
Right.
But I think everybody understood what the tariff was doing, and the tariff was incorporating the statute. As to that, I don't see any ground for concluding that there was disagreement. It seems like everybody had the same uniform understanding. And then they bracketed that, yeah, and I'm just quoting, what the settlement did not do was define grandfathering for purposes of the WDT. The parties were aware that they did not fully agree on the interpretation or scope of grandfathering under Section 212H, and that issue would need to be resolved. But that has been caveated.
I would emphasize again the language Your Honor just read, that the parties did not agree on grandfathering, and that's a word that's in the tariff, not in the statute. And the statute only refers to the two criteria. What are the criteria of 212H? They are that a state or political subdivision and that that the entity is providing service on October 24th, 1992. There's nothing in that language that would help the commission determine whether this tariff should grandfather a class or existing delivery points. And
but
what the commission
precedent under 212F does answer that question.
Suffolk.
FERC's case law, suffix 2, answers that question. Now, FERC's response is, well, this isn't a 212F case. Of course it's not a 212F case. But the parties, the language of the tariff incorporates Section 212F into the tariff.
I would add to that analysis.
No, you don't have to add to it. What's wrong with what I just said?
Well, I would point out in paragraph 28 of the rehearing order that the commission observed that there is a type of class application of grandfathering that PG&E does with these replacement agreements. It's actually the same as San Francisco's approach.
Okay.
The difference is that the commission doesn't approve grandfathering in perpetuity for new or relocated delivery points. And given the delivery point framework of this tariff, the commission was reasonable to make that finding.
Can you just tell me once more? I'm sorry I asked the question, my initial question. I'm sorry I asked both about the language of the tariff and the intent of the parties, because we ended up talking about the intent of the parties. Can you go back to the language of the statute? I'm sorry, the tariff, and tell me what's ambiguous about quote, except in the case where an eligible customer meets the criteria for grandfathering in Section 212A. What's ambiguous about that?
If I may respond with two ways to that, Your Honor, I think what the commission is finding, and this goes back to paragraph 69 of the initial order, the commission is looking at this language and finding ambiguity. The language does not simply say except where.
Where is the ambiguity, Mr. Edinger? That's what I don't. I know the commission found ambiguity, but where is it?
Okay, the language doesn't read except where an eligible customer meets. It's in the case where an eligible customer meets. And the second sentence to the tariff is also important, that begins with, to the extent an eligible customer intends to invoke the grandfathering provision, the eligible customer must do so as part of its application, and at that time must provide evidence demonstrating that for each point of delivery. And I think what the commission is finding is that it's striking that that doesn't read simply that evidence demonstrating it meets the criteria of 16 USC 824K. If it read something like that, it might be clear that a customer class is grandfathered, and the commission disagreed with that interpretation of this tariff. And in addition to all the other...
And what about Suffolk 2?
And as the commission explains in paragraph 69 of the initial order, that the Suffolk type precedent isn't sufficient to overcome that delivery point framework here that's evident in section 14.2 and other sections. Sorry.
We're going in circles. I get your argument. I hear your argument.
So there was one point being made, I think you referenced it, and I know the commission has too in the briefing and in the orders, that it seems difficult to believe that there would be this kind of in perpetuity result. That is the result of Suffolk, right?
That may be the result of Suffolk. Again,
why is there even a may? I thought that is the result of Suffolk.
That I just don't want to get in front of the commission on this. Isn't there's a public interest component of section 210 and 211, and I don't want to get in front of the commission what the commission would have determined had this been a case under those sections. I think in fact the commission makes this point explicit in its footnote.
But I think the result of Suffolk is that a class gets protected in perpetuity.
If that's the way the case is applied, I just don't know that it absolutely would. There are other parts that, like I said, there's a public interest component of those proceedings. This isn't one of those proceedings, and I just don't want to prejudge what that case would look like. But there is a class. I think the commission is acknowledging here that there is a type of class approach under Suffolk.
Okay, unless my colleagues have additional questions for you,
No.
Mr. Edgar.
Thank you, Your Honor.
Thank you. We'll hear from PG&E Intervenor Counsel, Mr. Levenberg.
Thank you, Your Honor. May it please the court, Joshua Levenberg for Intervenor Pacific Gas and Electric Company. I'd like to turn to a couple of the questions that you asked to counsel previously, in particular, the joint brief.
So was the commission wrong that that's not what you agreed to?
I think the commission is right in that what we agreed to was what Judge Srinivasan suggested earlier, was that we were going to let the commission determine when this issue came to the commission, what that meant, how to interpret the statutory provision in light of the context of this case. The reason that I think that I might disagree with perhaps some of the hypotheticals that you were proposing before is that both parties were aware of the underlying precedent at FERC, the Suffolk cases. And before they entered into the agreement, before they filed the brief, in fact, the complaint that San Francisco filed in the fall of 2014 arose because San Francisco made an application to PG&E to apply grandfathering to all of its delivery plans. San Francisco rejected that based upon its interpretation of 212H. San Francisco said, we're relying upon Suffolk to say that they're all grandfathered because they're all in the class. And PG&E said, that's not our interpretation. PG&E's interpretation embedded in the statutory, embedded in the tariff to refer to the statutory provision was to use a temporal delivery point approach as the statute reads, which is in service as of that date, then you are grandfathered. But the new approach, which was the new wholesale distribution tariff, required intervening facilities on a going forward basis. So PG&E's interpretation was any new applications are going to have intervening facilities, just like all of our other customers do. But when this is new to you, you had a different agreement before where you didn't need those, but all other customers have been required to install intervening facilities. So if you don't have them as of the date that the tariff becomes applicable, we'll leave them and serve them as is, but on a going forward basis, you will need those.
So do you disagree? I thought what the commission had told us was that, what Commission Counsel just told us, is that the parties intended to incorporate the commission's decisions.
Absolutely not. I don't think that was an agreement at all. And as I said, that dispute has been a dispute between San Francisco and PG&E since at the earliest 2013, articulated between the parties, and PG&E's answer to San Francisco's complaint makes it clear that we do not interpret 212H to mean what San Francisco does. San Francisco insists that the statute must be read in light of, or you have to read in FERC precedent into that interpretation. And neither the tariff nor the statute include the language that says class of customers.
But the last sentence of that paragraph on 613 says the intent of referencing section 212H in the WTT as it pertains to grandfathering was to ensure that the commission's interpretation of the statute was incorporated into the WTT's eligibility rule.
Right. And I think from our perspective, that was a prospective interpretation. When it gets to FERC, we will live with whatever the decision is. That decision was that the prior precedent doesn't apply in this case. And that's why we're here.
Mm-hmm.
Wait, it says, so let me see if I understand this. So you think the language, here, quote, let's see, to ensure that the commission's interpretation of the statute was incorporated into the eligibility rules, right? That you say that what you were talking about there was whatever the commission's future decision was?
Pardon me, I couldn't hear the end of your...
I'm sorry, this is referring to a future commission interpretation, not the current one?
Correct. I mean, as we discussed in our brief, the chronology of events was such that the decision to include that language in this...
But I don't understand why... Why would that even be on the table? I don't get it.
It arose because in 2013, PG&E filed a new wholesale distribution tariff. And as part of, while those negotiations were ongoing, the dispute arose about how to interpret grandfathering, the grandfathering clause of 212H. Despite the fact that the complaint was filed... I'm sorry to interrupt
you. I'm really trying to understand your argument. Why would the parties have to agree on that a future FERC decision interpreting that a future FERC decision was incorporated into the tariff? Wouldn't it automatically be when the FERC interprets the tariff, that's the interpretation of the tariff? The parties don't have to agree on that.
The reason was because it was still being disputed. So that was a live issue in a FERC proceeding. In order to settle what was the wholesale distribution tariff litigation, and that settlement wasn't approved by FERC until the day before the new tariff became effective for purposes of San Francisco. The only way to settle that was for both parties to agree to put a placeholder in there.
What do you think?
Had PG&E thought that had PG&E thought that the precedent applied, we wouldn't have been litigating from 2013 until today. We would have said that the precedent applied.
The other side of this is, okay, so San Francisco's on the other side of this agreement. What's Ms. Mate going to say when she stands up here and I ask her what she thinks about what you just said?
I mean, I think their brief makes it clear that they think...
You think she agrees with this?
They think that the tariff embeds the FERC precedent that was distinguished. That's the approach that San Francisco has been taking, but that's not what the language of the tariff says. And the language of the tariff was negotiated after the complaint was filed.
Do you have any other evidence to support this interpretation of the language? I don't mean the interpretation. I mean, do you have any other evidence you can point us to that this is what you meant? I mean, as your client meant when it said...
In the record, I think it's just a chronology of events. As I said, we filed a tariff in 2013 to require intervening facilities. San Francisco then applied for service, saying all of our points are grandfathered because we don't have intervening facilities and we're grandfathered.
Yeah.
PG&E rejected that approach and said you're not grandfathered. We're not using a class of customers approach. That approach is not applicable here. San Francisco then filed a complaint saying we want FERC to decide, is it class of customers or not?
Do you read the commission to have actually carried out what even you are saying was the intent of the statute, which is to ensure that the commission's interpretation of the statute was incorporated?
I do.
Because I thought the commission made pretty clear that it wasn't interpreting the statute because...
as I said, I think San Francisco took an approach that was the statute should be interpreted through the lens of Suffolk. And PG&E's interpretation was that the statute should be interpreted through the lens of the face value of it, which was drawing a temporal line in the sand. So in 1992, when Congress amended the Federal Power Act, it stated that from this point forward, intervening facilities would be required. but any existing interconnections that did not have intervening facilities were grandfathered. That's PG&E's approach. And so that's when the commission issued its order, that's the approach that PG&E had proposed and proffered throughout.
Let me ask my colleagues if they have any additional questions for you,
No.
Mr. Levin.
If you don't mind, I'd like to at least respond to one of Judge Tatel's questions to San Francisco about what the impact is.
Yeah.
And I think it's worth mentioning that in the grandfathering context, there has been no impact. In fact,
What, I'm sorry, in the grandfathering context, what?
the context of you, I think you asked,
Yes.
what's the impact of the outcome of both of these cases,
Yes.
the primary versus secondary case and the grandfathering case.
Right.
I think in the context of the grandfathering case, there's been no impact. So the fact that FERC ruled in favor of PG&E has not led to any changes at San Francisco. San Francisco sort of had in its briefing a suggestion that there was off-tariff service or this alternative. In fact, all of the delivery points that were previously served under the prior 1987 interconnection agreement have currently been served under the wholesale distribution tariff. There have been no disconnections. There have been no, the concerns were that PG&E was going to say you're not grandfathered and therefore you're converting it to PG&E's retail service. There are zero examples of that. So nothing has happened. There's been no impact to San Francisco because of the grandfathering decision. With respect to the primary versus secondary decision, which is, there's an overlap. I think San Francisco, we have had disputes, and I think some of them are raised in San Francisco's pleadings. But I think, ultimately, what I think is important to understand, which I think appears in our briefs, there's nothing that prevents San Francisco from providing secondary service to its own customers. It's a utility. So that case seems to me to suggest when San Francisco says we don't want to do this because it would be expensive or we don't have room, the argument I think is that why should that responsibility be foisted upon PG&E? Why doesn't San Francisco take on the role or responsibility of providing secondary service to its own customers in the way that other utilities do?
You mean by developing intervening, right?
Pardon me?
By developing intervening, right? Its own intervening.
Yeah, sorry, I couldn't hear you.
How would it do that?
All utilities have the opportunity to provide whatever facilities they want. So if you want to provide
so it would develop its own intervening facility.
Absolutely. Okay. San Francisco, if PG&E only provides primary service on a going forward basis, just like every other utility in the United States, San Francisco can step down with transformers and provide secondary service to its own customers. The question is, why should PG&E provide secondary service to San Francisco's customers directly? Why should?
Right. I think the question is, why should PG&E continue to? Because it's not as if the world started without any secondary service before.
Absolutely.
Their secondary service wasn't in existence, and the question is whether it's going to continue.
Okay, I'm done.
Okay. Thank you, Counsel.
Thank you. Appreciate it.
Ms. Mapes, you have the rest of your time remaining, which I don't know exactly how long it was. I think it was around 7 minutes.
Thank you, Your Honor. Well, I'll briefly address Mr. Levenberg's last point first, which is that it gets to the heart of why FERC exists. The reason San Francisco can't easily provide secondary service to its own customers is that it would have to build a duplicative distribution system throughout San Francisco for the most part. And by and large, we've, as a society, judged that to be an inefficient use of resources. San Francisco actually does own distribution facilities at various points within the city. For instance, it serves, and I believe this is in the record, the new Hunters Point development in a certain portion of the city, using its own distribution facilities. In an old space-constrained city like San Francisco, to serve streetlights, libraries, police stations throughout the city would truly require building a duplicative distribution system. You'd have two sets of wires running under the streets. I have a few other points I wanted to make. The first is related.
Could you address the party's joint submission?
Yeah.
And
Absolutely, Your Honor. And unsurprisingly, I do not agree with Mr. Levenberg about our intent. I think probably the best evidence in the record as to that is if you look at the briefs that PG&E filed before the ALJ, who heard this case at hearing at the commission, and its briefs on exceptions to the commission. PG&E argued whether or not its interpretation fit within FERC's precedent in those briefs. It did not argue that FERC's precedent was irrelevant to those briefs. It argued that its interpretation fit that precedent. It may also have argued that that precedent should be overturned. If the commission viewed differently, it did not argue that somehow 212H in this tariff exists in some kind of state divorced from the commission precedent, and that argument at no point appeared in the record until it appeared in the commission's order. Another point I wanted to make was that Mr. Levenberg mentioned that the statute, in his view, refers to points of delivery. I would point to the language in 212H, which refers to such ultimate consumer that was receiving power on October 24th, 1992. It does not refer to point of deliveries. It does not refer to locations. And I believe the commission's Suffolk decision, while not directly at issue here, was informed by that such ultimate consumer issue. I also wanted to address the contention that we haven't suffered any harm from the grandfathering decision. I would note that the new wholesale distribution tariff case that PG&E references in its briefs actually does terminate service to a very large category of load that PG&E has argued is not entitled to grandfathering, and that is its streetlights and other small municipal loads that have traditionally not been metered. PG&E has, since 2015, classified that load as not qualified for service under the wholesale distribution tariff and not entitled to grandfathering, and it now seeks to terminate service to that load. Originally at the end of the year, but I believe it is filed for a stay of a month or two. And its concept is that that load would become PG&E retail customers instead. And I wanted to offer one analogy that I thought might be helpful on the issue of the point of delivery framework in the tariff. I believe Mr. Edinger discussed, well, the tariff doesn't just say you apply for grandfathering, it says you apply for a point of delivery. And that's true, but I would note that the tariff contemplates that customers might apply for many points of delivery, and they might apply for many points of delivery at one time. So for instance, if San Francisco submitted an application for 10 points of delivery, and 5 of them were privately owned coffee shops, and 5 of them were public libraries, San Francisco would have the obligation under the tariff to show it owned intervening facilities for those privately owned coffee shops. And under San Francisco's interpretation, it could then show evidence of eligibility for grandfathering for the 5 libraries. And that's how our interpretation gives meaning to the point of delivery approach. And if there's no other questions, I'll thank you for hearing this case.
Could you just repeat the last point you were making?
Yeah, absolutely. And so the point I was trying to make there is that under the tariff's point of delivery approach, grandfathering belongs to the ultimate consumer that is taking service at a particular point of delivery. So if we submit multiple applications, 5 of them might be for customers like libraries that are eligible for grandfathering, and 5 of them might be for customers like Starbucks on private property that are not. So we would need to show that we owned eligibility, or we owned intervening facilities for those 5 Starbucks. And we would also show that we met the criteria of 212H as to grandfathering for the 5 libraries. So we would be presenting evidence for each point of delivery, but it may be different for each point of delivery, and we may be eligible for service for different reasons.
And in fact, Sam, as I think you pointed out in the briefs and in the record, San Francisco obviously has filed applications that involve showing that there are intervening facilities, because the grandfathering issue just doesn't even come up with some points of.
That's right, Your Honor. And the points at issue here, we have argued are entirely eligible for grandfathering, but that is effectively why we submitted them in this application. There are other points of delivery that were never part of this case where it's clear we own intervening facilities.
And therefore, grandfathering doesn't even come up.
That's right.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission as well.
This honorable court is now adjourned until Thursday, December 2nd at 9:30 a.m.